Morning, all. E.
Good morning, sir.
Good morning.
Good morning.
Can everybody hear me?
Yes, good
Sure
morning.
can.
Okay, thank you. Great. We're not on the record yet, but about to go on the record. We have, as you may remember from the pre-hearing order, there's a requirement that only one attorney per party be present on the actual Zoom screen or in the Zoom call at a time. And we have requests for admission from additional attorneys who, for parties that already are represented on screen. So,
Mr. Medeiros,
Mr. Elliott,
my apologies for interrupting.
can you, when you wave, could you raise your hand like this instead of like that? Because I didn't know what you were doing there. I'm sorry. Go ahead.
No, my apologies. My colleague, Kevin Gedko, will be representing the office this morning as I have another commitment. So,
All right. I just admitted him.
thank you very much. I will now drop off, okay?
Okay. Thank you. For the time being,
Mr. Medeiros?
yes, sir.
So I am going to be cross-examining Mr. Monroy, which is why I'm on. Ms. Beatles will be our lead attorney, and for most of the hearing, she will be the one attending the hearing, and I will be watching on the webcast. But since I was going to be up first, I went ahead and asked to be entered. But if you, I can go ahead and represent WRA until my cross-examination is finished, at which time it would be prefer to have Ms. Beatles be the participant in the hearing.
Right. Okay. Well, what we're going to do with the attorney appearances was have, I thought, but was enter the appearance for you. Whoever was leading off would enter the appearance for the party and then indicate what you just indicated. So when I take appearances, for instance, Mr. Gedko, please enter the appearance for the Attorney General, and for the Attorney General, enter your appearance on behalf of yourself and Mr. Elliott, if that makes sense.
Yes, do you want me to do that right now? Yes.
No, we're not on the record yet, but are there any preliminary matters that the commission needs to be aware of before we do go on the record?
Mr. Hearing Examiner Rick Alvidrez.
Morning, Mr. Alvidrez.
Good morning. Over the weekend, one of our witnesses, Michael Settlage, fell quite ill with a very high temperature. He did go to the emergency room, has been confirmed not to have COVID, fortunately, but still remains ill with a high fever. So what we would ask is that his testimony be moved to as the last witness, as a precaution in order that he might have some recovery time. If his health doesn't improve enough for him to appear, our alternative would be to have a different witness on behalf of Pnm adopt his testimony. Most likely that would be Stella Chan, but we're hopeful that this is a short duration illness and that he will be able to appear later in the hearing, as opposed to tomorrow when he was scheduled.
Any objection to moving Mr. Settlage to the end, and then possibly using another witness to sponsor his testimony? That witness might be Ms. Chan, Ms. Stella Chan. Is there any objection to that?
No.
I'm doing this off the record, but that's fine. But most importantly, my thoughts go out to Mr. Settlage, and I hope he has a full and fast recovery. And the illness is not serious, so I convey that to Mr. Settlage directly. Okay. Very well then. Is there anything else before I do start? I'd like to move, once we do start, I'd like to move right into the presentation of evidence if possible. So hearing nothing else. Morning, Ms. Gonzalez. Are you ready to roll? Okay. All right, let's go on the record then. This matter before the New Mexico Public Regulation Commission will please come to order. This is a time and place set for the evidentiary hearing in this proceeding established by order of the New Mexico Public Regulation Commission on March 30, 2022, to consider the joint motion for order to show cause and enforce financing order in case number 19-00018-UT, filed by Joint Movements Western Resource Advocates, Coalition for Clean Affordable Energy, and Prosperity Works on February 28, 2022. Good morning. My name is Anthony Medeiros. I and Chief Hearing Examiner Ashley Schanauer were assigned by the Commission to preside over this matter. I'd like to start today with the appearances of counsel for the parties, starting with the Joint Movements. Who appears for Western Resource Advocates, or WRA?
Good morning, Mr. Hearing Examiner. My name is Stephen Michael, and Sydney Beatles is also appearing on behalf of WRA.
Good morning, Mr. Michael. Coalition for Clean Affordable Energy, CCAE, and Prosperity Works. Let's see, I thought I had seen Ms. Zer and Ms. Lynch, but okay, here I'm admitting Ms. Lynch as we. Ms. Lynch?
Oh, good morning. Apologies. I've just been communicating with co-counsel about who should appear here right now. I'd like to introduce myself and my co-counsel. I'm Kara Lynch, attorney for CCAE and Prosperity Works. Anyway, my co-counsel for this matter is Stephanie Zer. She will be representing CCAE's position. Thank you.
And are you saying that you'll be representing Prosperity Works position, or are you also representing CCAE?
I'm representing both CCAE and Prosperity Works. Stephanie is
Okay.
representing CCAE only.
All right, that's what I thought. Okay, thank you. Good morning. And next, who appears for the respondent to the joint motion and applicant in the first phase of this proceeding concerning the abandonment and securitization of the San Juan Generating Station, Public Service Company of New Mexico, or PNM.
Yes, sir. Good morning, Mr. Hearing Examiner. Rick Alvidrez on behalf of Public Service Company of New Mexico. Also appearing in this proceeding will be Debra Terwilliger on behalf of PNM. She is watching by YouTube, but I'll be handling our first witness this morning.
Good morning, Mr. Alvidrez. Thank you.
Good morning.
All right. Now, the appearances of intervener parties and staff, going roughly in alphabetical order. Bernalillo County.
Yes, good morning, Mr. Hearing Examiner. Jeff Albright, representing Bernalillo County from J. Albright Law, LLC.
All right. Interwest Energy Alliance. I believe Ms. Drake was excused, although I thought she was going to enter an appearance and be off, have to leave at around, I think I excused her from the hearing entirely. So pursuant to an email. So forgive me for that. So Interwest Energy Alliance is excused from attendance at the evidentiary hearing in this matter. New Energy Economy, or NEE.
Good morning, Mr. Medeiros and Mr. Schanauer and colleagues. My name is Marielle Nanasi on behalf of New Energy Economy.
Good morning, Ms. Nanazi. New Mexico Affordable Reliable Energy Alliance, or NM area.
Good morning. My name is Kelly Gould on behalf of New Mexico Affordable Reliable Energy Alliance, or NM area.
The New Mexico Attorney General.
Good morning, Mr. Hearing Examiner. My name is Kevin Gedko, and my co-counsel will be Gideon Elliott. Thank you.
Good morning, Mr. Getsko, and good morning, Ms. Gould. Sorry for not greeting you this morning. Sorry. So good morning, Ms. Gould, too. Then the San Juan Legislative Delegation.
Good morning, hearing examiners and parties. This is Jermaine Chappelle representing the San Juan Legislative Delegation.
Morning.
Good morning.
Sierra Club.
Good morning. This is Jason Marks here for the Sierra Club.
Morning, Mr. Marks. And finally, but never last, staff.
Thank you, Mr. Hearing Examiner. My name is Bradford A. Borman, appearing on behalf of Utility Division staff. I expect to be the sole attorney representing staff during this proceeding unless I get hit by a bus.
Let's hope that's not the case.
Let's
Good
hope
morning,
so.
Mr. Brad. Good morning,
Thank
Mr.
you.
Borman. All right. Are there any preliminary matters before we move to the presentation of evidence?
Yes, Mr. Hearing Examiner.
Mr. Albright? Good morning.
Yes, sir.
Again.
And just to reconfirm my earlier request to periodically be excused from the hearing, I have some other commitments that come up, and certainly I agree to abide by any decisions made by the hearing examiners or any rulings, and to forego cross-examination if it happens to fall during a period when I'm absent.
All right. Thank you, Mr. Albright. Yes, you will be excused periodically, but thank you for entering your appearance. And yes.
Thank you, sir.
Your request is granted.
Thank
you.
Mr. Medeiros, Rick Alvidrez.
Yes, sir.
We had a discussion off the record about Mr. Settlage and moving him. Do we need to, and also a potential substitute witness for him? Do we need to get that on the record?
But in discussion, thank you, Mr. Alvidrez. In discussions off the record just before we started, which was recorded on YouTube, so you all may have heard, Mr. Settlage has fallen ill with a high temperature. Fortunately, it is not apparently not COVID. However, he is very ill, and so in off the record discussions, the commission agreed to move Mr. Settlage to the very end of the list of witnesses in the pre-hearing order. If Mr. Settlage hopefully is recovered well enough, he will testify on the last day of the hearing. Otherwise, PNM will likely use another witness to sponsor and testify on Mr. Settlage's testimony, and that would possibly or likely be Ms. Stella Chan, who has testified before the commission before many times. That was agreeable to the commission and was accepted. Thank you, Mr. Alvidrez, for reminding me of that. All right, is there anything else? Very well then, let's proceed to the presentation of evidence, the schedule of witnesses and order of cross-examination were established in the pre-hearing order issued by the hearing examiners on May 20th, 2022. That's the pre-hearing order I just referenced. Therefore, pursuant to the pre-hearing order, would PNM call its first witness, please?
Yes, sir. We call Henry Monroy as our first witness.
Good morning.
Morning, Mr. Monroy. Ms. Gonzalez, would you please swear the witness? Ms. Gonzalez?
Yes.
Oh, there we go. You were, it sounded like you were muted, or I'm sorry, go ahead.
Let me get a little closer. Can you hear me now?
Yes, ma'am.
Okay.
Thank you.
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you.
Mr. Monroy, for the record, can you please state your name and employment?
Yeah, my name is Henry Monroy, and I'm employed by Pnm'S Services Company.
And did you submit pre-filed testimony in this matter that has been marked as P&M Exhibit SC1 as your direct testimony dated direct testimony in response to April 1, 2022 procedural order in this matter?
Yes, sir.
And do you have any corrections to note with respect to your pre-filed testimony versus what's in P&M Exhibit SC1?
I do have some corrections.
Will you please take us through those corrections?
Yes. On the table of contents on page I would strike the word confidential next to PNM Exhibit HEM-12, parens April 20, 2022. On the same page, I would strike the word confidential after Q1 income statement. On the same page, I would strike the word confidential next to PNM Exhibit HEM-14, parens April 20, 2022. And on the same page, I would strike the word confidential after 3-31-2022. On the table of contents, page 2i, I would strike the word confidential next to PNM Exhibit HEM-16, parens April 20, 2022. On the same page, I would strike the word confidential after ROE. Moving to page 40, line 14, strike the word confidential. On page 40, line 17, strike the word confidential. And page 41, line 5, strike the word confidential.
And Mr. Monroy, have these corrections been interlineated on the P&M Exhibit SC1 that was uploaded to the Dropbox?
Yes, sir.
And with those corrections that you just led us through, if you were asked the questions that appear in your direct testimony today, would your answers be the same?
Yes, sir.
And are the answers contained in your direct testimony true and correct to the best of your knowledge and belief?
Yes, sir.
With that, Mr. Hearing Examiner, we move the admission of P&M Exhibit SC1 into evidence.
Objection?
Yes, hearing examiner Kelly Gould for NM area. I object on the same grounds as listed in my motion in limine on res judicata and relevancy grounds to the portions of the testimony that are outlined in the motion in limine. Thank you.
And Ms. Gould, that objection has already been ruled upon, hasn't it?
Yes, I'm making it for the record, so to preserve my objection. Thank you.
It wasn't unnecessary, but thank you for making it anyway. Objection overruled. I understand that you have we have another pending motion in limine. Is that correct, Ms. Gould?
Yes, that's correct.
And that relates now to Ms. Sanchez. Is that correct?
And also portions of Mr. Monroy's rebuttal that has not yet sought to be introduced.
Well, that's going to pose a problem because PNM may seek to introduce it now. And actually that, well, we'll have to see what we'll do with that, but you may actually get a preliminary ruling on that in a minute. So let's see what happens. Okay, so with the objection overruled, PNM Exhibit SC1 is admitted. Mr. Albiga?
Excuse me, Mr. Medeiros.
Yes.
There was an errata filed earlier that had a number of changes to a number of tables in the testimony, and I don't know that I don't see the errata being offered into evidence, and I don't see those changes to the tables being made in the testimony that we just heard.
Well, Mr. Shanauer, my understanding was that it was the corrected testimony that was being admitted, but that I may have been mistaken. Is that, Mr. Albides, could you clear this up for us?
Yes, the testimony that was presented does reflect the errata revisions.
They're interlineated, is that right?
It is interlineated on the specific pages.
So you wouldn't seek the admission of the errata?
No, sir. The errata has been incorporated into this version of the testimony that you're ruling on right now.
That's right. That was my understanding. Mr. Shanauer?
That's fine. I just did not understand that and thought that needed to be made clear for the record.
Yes.
Yeah, and what Mr. Shanauer is referring to is that that should be noted going forward, because that's reflected in the pre-hearing order. Nevertheless, what was uploaded is the corrected testimony. That was what was admitted, was a corrected testimony, which reflects the changes included in the errata. All right, go ahead, Mr. Albides.
Yes, thank you, and thank you for clearing that up. Mr. Monroy, did you also prepare May 18, 2022 rebuttal testimony that we marked as P&M Exhibit SC2?
Yes, sir, I did.
And do you have any changes or corrections to that testimony?
No, I do not.
So if you were asked the questions that appear in P&M Exhibit SC2 today, would your answers be the same?
Yes, sir.
And is this testimony true and correct to the best of your knowledge and belief?
Yes, sir.
Mr. Hearing Examiner, we move the admission of P&M Exhibit SC2.
Any objection?
Yes, Mr. Hearing Examiner, I object pursuant to res judicata and relevancy grounds as set forth in my second motion in limine regarding rebuttal testimony.
Thank you, Ms. Gould. I think the way we're going to handle it is I'm going to provisionally admit P&M Exhibit SC2 subject to a final ruling after reviewing P&M's response to your motion, and that response is due tomorrow morning at 8:30. So I will just simply provisionally admit P&M Exhibit SC2 subject to a final ruling after reviewing P&M's response, and of course addressing your motion.
Thank you. Mr. Hearing Examiner, can the record please note my standing objection to any questions that are asked regarding those portions of the testimony set forth in my motion in limine?
Yes, ma'am, the record so reflects.
Thank you.
So with that, thank you. So with that, P&M Exhibit SC-2 is admitted provisionally, subject to NM area's objections.
Mr. Hearing Examiner, Mr. Monroy is available for cross-examination.
Thank you, Mr. Albides. I believe up first is WRA, Mr. Michael, and you reserved 45 minutes with Mr. Monroy, is that correct?
That's correct, Mr. Medeiros.
Okay.
Thank you.
And Mr. Michael, what I'm going to do is we have an app now on the Zoom that you may have noticed me using during the public comment hearing. So at about 5 minutes, if I remember, or around that time, you'll see a little box show up on my screen. Would you prefer that, or is that all right? Or would you like a verbal warning? What I'm trying to do is avoid slowing down or interrupting cross-examination. So we're going to try that method. Is that all right?
Yeah, a verbal warning would actually be helpful if you remember to do that.
I will do that. It's just that, you know, I'm loath to interrupt anybody's cross-examination, but we do need to give you some sort of warning. So I'll try and do that. So your time starts now, Mr. Michael. Go ahead.
Okay.
Thank you.
Good morning, Mr. Monroy.
Good morning, Mr. Michael.
Could you turn to page 4 of your direct testimony, please? And at the time P&M filed its original request in this case, for financing approval. The company intended to issue the bonds at the time the plant was abandoned. Is that right?
I do apologize. You broke up there just slightly. Do you mind re-asking your question? I'm sorry. I had a blip in my sound.
Yes, at the time P&M filed its original request in this case for financing approval, it intended to issue the securitization bonds when the plant was abandoned. Is that right?
Yes, at the original application, P&M's plan was to issue the bonds near the time of abandonment, and also to have implemented a rate case to reflect the changes in base rates associated with the abandonment of San Juan, as well as any other changes in P&M's cost of service. That is correct.
You represented to the commission that you were going to issue the bonds at the time of abandonment, right?
We provided, as per the financing order, the estimated time of when P&M planned to issue the bonds. And that's what we provided to the commission, was that estimate.
And that estimate was at the time of abandonment, right?
Correct. That was P&M's estimate at the time of planned issuance of the bonds.
Okay. Now you say at line 12, and I think you just, talked about that a minute ago. P&M was, quote, P&M was also clear from the beginning about its intention to time the issuance of the energy transition bonds with the effective date of rates from a general rate case so that San Juan costs were removed from rates at the same time the energy transition charges became effective. Do you see that testimony?
Yes, sir, I do.
Okay. Now, there is a difference between timing a rate case to coincide with a bond issuance and timing a bond issuance to coincide with the end of a rate case, right?
I'm not sure I understand your question on there's a difference. Could you ask
the
again?
difference is which of those events drives the timing of the other, right?
And which event are you referring to? I guess from our perspective, they were tied together. Or at least from my perspective, they were tied together.
The question is, there is a difference between timing your rate case to coincide with a bond issuance and timing a bond issuance to coincide with a rate case. One is a cause and one is an effect, right?
I guess I'm not sure I follow what you're wanting me to say. Like I said, in my mind, the two were tied together. One didn't necessarily exist in absence of the other.
Well, could you turn to, do you have your original testimony that you filed in this case back in 2019? On our exhibit list, we asked that you have that available to you.
My team's getting it to me as we speak. So,
okay. When you get that, could you turn to page 41 of that original testimony? Mr. Medeiros, is it possible to get some stoppage time for the time it's taking for Mr. Monroy to obtain that testimony?
Reflected on my screen. And for the record, what's reflected on my screen is 4056, as in 40 minutes and 56 seconds.
we might be able to short circuit this, Mr. Monroy. I could read you a sentence from that testimony, and if you would accept that subject to check, we can proceed. Is that acceptable?
Frankly, this testimony, PNM, this is directed to you. This testimony should have been in front of Mr. Monroy because I already had that highlighted. And so if I did, clearly you know what's being asked about there.
And we do have the prior testimony available. I'm not sure exactly what the delay is, but I know it's available there.
Okay.
So, Mr. Monroy, if I may, I'll just read you your testimony on line 6 of the page of that. And if you could accept that subject to check, we can move on. In that testimony, you said, however, if there is a timing difference between commencement of the collection of the energy transition charge from customers when bonds are issued upon the abandonment and the time that base rates are adjusted to reflect the abandonment of the San Juan coal plant, then regulatory liability will protect customers from double recovery of the undepreciated investments. Would you accept that that was your testimony, subject to check?
Of course, subject to check.
Okay. And so in that testimony, you recognize that those two events, the bond issuance and the conclusion of the rate case, might not occur at the same time, right?
Yes, sir. That is correct.
And the testimony reflected that the bonds would be issued upon abandonment. So if there was a disconnect between those two events, the bond issuance and the rate case, it was the rate case that was going to be disconnected from the bond issuance and abandonment, not the bond issuance and the abandonment occurring at different times, right?
I disagree. Like I said, I think the intent were for all three, or our estimate at the time, were that all three of those events were going to happen around the same time. And I apologize that we're not having my testimony. I did read it. Anyways, I think that whole Q&A actually talks about Pnm's intent to file a rate case for the rates to go into effect at the abandonment, and also then the plan to issue the bonds.
That's correct. It's just so for the record, it says, your testimony says, well, if you get the testimony before, it'd be helpful, but I'm just trying to move it along. Question starts on page 40, line 19. Does PNM anticipate adjusting PNM's base rates to reflect the abandonment of the San Juan coal plant through a general rate case at the same time that customers began to pay the energy transition charge? Answer, line 1, page 41. Yes, PNM intends to file a general rate case to reflect the abandonment of the San Juan coal plant for rates to go into effect at the same time as the energy transition charge are collected from customers. Anyway, in this instance, there will be no need for a regulatory liability to be recorded. Line 6, however, and then that gets into the dialogue we were talking about. Okay,
Thank
go
you.
ahead, Mr. Michael.
Okay. And just so the record's clear, PNM's proposal for regulatory liability was changed by the commission to provide an immediate rate credit rather than regulatory liability, with the amount reflecting the totality of San Juan costs embedded in PNM's rates, not just the capital costs. Would you agree with that?
Yes, sir, that is correct.
Okay. And PNM defended that order with those conditions on appeal, is that right?
Yes, sir, that is correct.
Okay, and on appeal, that order was affirmed by the state Supreme Court.
Yes, sir, that is correct.
Okay. And is it also true that PNM witness Eden proposed and the commission ordered the bonds to be issued, quote, as promptly as possible, unquote, after 4 conditions were met, one of which was abandonment, right?
I don't have Ms. Eden's testimony in front of me. So
Would you accept that subject to check?
Subject to check, sure.
Okay. And would you also agree that none of those conditions was the conclusion of a P&M rate case?
Once again, I'm not sure what the four things that you're referring to in Ms. Eden's testimony or what else she said. I do remember reading, and maybe it was in, I can't remember, something in prep, but I thought she was clear that it was based on P&M's current estimates.
In your testimony, you state or you testify that P&M delayed its rate case out of concern for customers and that the delay has benefited customers. Do you recall that testimony, or is that consistent with your testimony, that statement?
Yes, sir.
And isn't it also true that P&M delayed a rate case because its needs for additional revenues was questionable?
No, sir, that is not my testimony.
Okay. Now, you testify that during the years 2019, 2020, and 2021, P&M was earning an ROE exceeding 9%. Is that right?
Yes, sir, that is correct.
And you show that in the table on page 18, right?
Yes, sir.
Okay. And do you have in front of you exhibit WRA SC2?
Let me grab it. I'm not sure what's going on around here. My assistant has left, but I think I see the binder. Give me 1 second. I apologize for having to stand up. Okay, I have WRA SC-2 in front of me.
And those are the affidavits submitted to the commission by Mr. Baker in case 12-0007 that reflect sort of reflect an ROE of the company based on certain assumptions. Do you agree with that?
Yes, sir. This is our submitted affidavit of Thomas S. Baker, providing for P&M's return on equity for 2019 was 9.622%.
Okay. And so were those affidavits, was that the foundation for your for the numbers that are in the table on page 18?
That are on the what?
I'm sorry, someone spoke and I couldn't hear what.
That was a question
Sorry,
from the court
I was,
reporter.
yes, I was, let me get closer to this. I'm very, very sorry. Okay. Yeah, I needed your question again. I'm sorry.
And were those affidavits the foundation for the numbers in your table on page 18?
Yes, sir. It was pulled from this report.
Okay. Mr. Hearing Examiner, I move the admission of WRA Exhibit SC2.
Any objection?
No objection.
Okay. WRA SC-2 is admitted.
Now, at line 6 and 8, you discussed that new investments in P&M's current cost of service have been offset by load growth and declining costs since your last rate case. Do you see that?
Could you give me a page number on line 6 and 8? I apologize. Or are you in my direct testimony from April 20th?
I believe it's still on page 18.
Oh, okay. All right, go ahead. Yes, sir. I'm there.
Okay. You say that system improvements and new investments and inflation have been offset by load growth and declining costs since P&M's last rate case,
Yes, sir.
right? And you say that the path forward until P&M's rate case reflects a balanced approach of customer rate stability, grid investment, and reasonable utility returns, right? And I'm looking at the bottom of the page.
Yes, sir. I see that.
Okay. So in fact, the situation today, according to your testimony here, is a balanced one where utility returns are sufficient to meet the cost that the utility is incurring, right?
I agree with that. Yes, sir. That is the situation today. Yes, sir.
Okay. So you don't need additional rates right now. You don't need additional revenues right now, according to this testimony.
I believe our testimony was providing what the rate increase will be after in the future, not what the rate increases have been in the past.
Okay. But you have testified that you foregoed, I don't know what the past tense of that verb is, foregone, that you determined not to file a rate case out of concerned customers when in fact, you don't need any additional revenues right now, do you?
So there's two rate cases I think you're referring to. So originally back in spring of 2020, we did have a planned rate increase that would have gone effect into the spring of 2021. Obviously that was then COVID-19, the pandemic hit, and a lot of things changed going forward from there. And so then that rate case was foregone. I'm not sure what the verb tense is either, due to the COVID-19 global pandemic. One of the things that happened with COVID-19, there was a significant change in usage in our customers. Residential usage increased greatly, and many other underlying cost of service items changed. And so the fact that what actually came to forbear in the future versus does not negate the fact that based on our financial forecasts, a rate increase was needed at that time based on the information available. And then I apologize. And then the second rate case, like I said, is one we were projecting from a test period that has yet to start.
So let me back up. Right now, and you withdrew that decoupling case, right? Your request for decoupling adjustments, or it was denied, but in any effect, it's not in effect right now, right?
Yeah, I'm not sure legally what happened to the disposition of that case, but you're correct. It was not implemented.
Okay. And based on your testimony here today, right now, P&M's revenues are sufficient to cover its costs.
I believe my testimony is you were referring to our reported earned returns. And so, for example, in 2021, we earned a 9.149%, which is below our allowed return.
I'm looking at the bottom of the page 18, where you say the path forward until P&M's next rate case reflects a balanced approach of customer rate stability, grid investment, and reasonable utility returns.
Yes.
Okay.
I mean, I'll just, the first part of that sentence is while P&M will need to file for a rate increase. But yes.
So right now, your rates are sufficient to cover your costs.
I would say our rates are just and reasonable based on what the commission has approved, and will remain that until P&M files for a general rate case to reflect a change in those rates.
Okay. Now, if the commission were to order the rate credit at issue here, $98 million per year, or whatever the number is, that is the amount of San Juan costs currently embedded in your rates that would not be incurred after abandonment, right?
Yes, the 98.3 million reflects the amount that was included in the cost of service used to set rates that are in place today.
Okay. And so that credit would be crediting customers by an amount equal to costs that you would avoid after abandonment, right? That's where that number came from.
Yes, I mean, I don't want to repeat what that 98.3 million is, but that's what that number reflects. However, what is being requested is a refund of what current rates that have been set by the commission are based on, and therefore does not reflect what Pnm's underlying cost of service to provide electric service to customers is.
I understand what you're saying. I am asking you whether that $98 million is matched to the costs that would be avoided upon abandonment. And I believe you testified they would, so we can move on.
And I guess I'll clarify that. Can I clarify that? It does not.
I think you just did, right? Are you going to just repeat the answer you provided?
No, sir.
Mr. Examiner Rick Alvidrez, can the witness please finish his answer?
Go ahead, Mr. Monroe.
I have no objection to you clarifying your answer, but I do have an objection to you repeating your answer given my limited time.
Clarify your answer, Mr. Monroe.
Thank you. And it's just a comment that you made. The 98.3 is the revenue requirement that was included in rates. However, is not reflective of what the costs are associated with San Juan, say, for example, in 2022, as those costs have continued to decline. And so I just wanted to clarify, it does not represent the amount of costs that we're incurring today that will go away upon abandonment. As those costs have already, excuse me, sorry, Mr. Hearing Examiner.
No, and that cost that you're referring to is, I can't remember right offhand, but it's 50-some million, is that right?
That is correct. For 2022, we are estimating 58.7 million.
And I'm saying that now because that figure may come up during this hearing again. So start us off with that number. We'll know what we're talking about. I'm sorry. Go ahead, Mr. I paused you for a short amount of time there. So go ahead.
So could you go back to page 4 of your testimony, Mr. Monroe?
Yes, sir, I'm there.
And on that page, you say that P&M delayed its planned cases, quote, primarily because of COVID-19, so as to not negatively impact customers who are struggling with the economic fallout from the pandemic. Do you see that?
Yes, sir.
And you also described that further on page 11 of your testimony. Would you agree that, and I think you may have said this, the customers hardest hit and least economically hardest hit by COVID were small commercial customers who suffered lockdowns, shutdowns, and so on. Would you agree with that?
It's not for me to opine on which of our customers were more impacted by COVID. I think, I know a lot of people lost their jobs, and so it's not for me to opine on who was impacted harder.
That's fine. Would you agree that the small commercial customers in your service territory were hit hard by COVID?
I guess I would agree that the sales or the usage of electricity declined as a result of COVID.
Okay. For those customers, unlike residential customers.
This might be questions better asked to Settlage, but from what I remember is usage per customer for our residential customers increased. So they increased their use of electricity, and we had decreased electric sales in our commercial classes.
Okay.
How that impacted small commercial versus general or large, I don't have that detail.
Okay, thank you. And could you turn to Exhibit WRASC4? which was a discovery response provided to new energy economy.
Yes, sir, I have it.
Okay. And this is a long-range plan update for P&M resources to the Board of Directors on March 5th, 2021. Do you agree with that?
Yes, sir.
Okay. And could you turn to page 12 of 18 of that exhibit?
Yes, sir, I'm there.
Okay. And if you look at the top of that page, it shows that in March of 2021, P&M expected its decoupling proposal to provide additional revenues in 2021 of approximately or of $15.9 million. Do you see that?
Actually, it shows that in our long range plan that was provided in August of 2020, that was the estimated impact related to decoupling revenues for 2021. If you look at the column over by March of 2021, we assumed no decoupling revenues for 2021 or 2022.
But at the time you filed your decoupling proposal, you were anticipating additional revenues of 15.9 million, right?
That was, yes, so that would have been the plan or the assumptions under the decoupling when we filed it back in May of 2020.
Okay. And so, and that proposal was directed entirely towards residential and small commercial customers, right?
Yes, sir.
Okay. And I believe you testified that, in fact, the residential usage increased during the pandemic while commercial usage declined, right?
That is correct. And so even though these were our assumptions,
so to the extent that there were increased revenues or anticipated increased revenues of $15.9 million, and those were realized, it would have reflected actually more revenues than that coming from the commercial class, right? Because residential usage had gone up, which would have reflected a negative revenue requirement from those customers during the pandemic. You follow my question?
not really. I apologize. I'm not sure what you're asking me.
If the company, let's just call it $16 million. If the company was to realize $16 million in increased revenues as a result of decoupling, and a part of that net $16 million reflected a negative revenue adjustment for residential customers because their usage went up, that would mean that more than $16 million would be recovered from the commercial class of customers.
I'm not sure how the relationship may or may not have played out. I will point out, I did confirm with our pricing department. And like I said, these were the estimates at the time. Obviously, this was before COVID, so we really didn't know what the impacts nor the duration of COVID, but did confirm that between 2020 and 2021, if Pnm's decoupling mechanism had gone in place, that the net under collection between those 2 years would have been approximately less than $2 million. And so obviously our estimates were based on what was known at the time, given with COVID impacts and the change in customer usage patterns, those numbers would have been significantly different had the decoupling proposal been approved.
And that $2 million shortfall, or what portion of that was to come from residential and what portion from commercial? Residentials would have seen a reduction, right? And commercial, an increase?
I did not get the breakout between customer classes. So, but perhaps Mr. Setledge would be able to provide you that information.
But in any event, the commercial class would have received an increase as a result of the decoupling proposal had it gone into effect, right?
Once again, I'll defer to Mr. Setledge. I got a total impact, and so I don't want to speculate or guess.
Is there any way that residential usage per customer could have gone up and the company increase its revenues as a result of decoupling without the commercial class seeing an increase?
I don't know. I'm not sure. I didn't think the decoupling was tied from what one customer class usage was to another. But once again, I would defer to Mr. Setledge and pricing if you have more questions on decoupling to clarify.
Now, could you turn to page 6 of your testimony?
Yes, sir, I'm there.
And would you agree that one of the purposes of the ETA was to provide financial assistance to impacted communities to help them transition when a coal plant was abandoned?
I would agree. I believe the ETA in section 16 specifically addressed those affected communities.
Okay. And the source of that funding was proceeds from the bond issuance, right?
That is correct. That is where the cash would come from.
And would you also agree that it makes no sense for transition assistance not to occur until years after a plant closes, years after employees have lost their jobs, and years after the economy has been impacted?
I guess it's not for me to say if the ETA makes sense in that regard. I will say PNM identified that, and in our original application actually requested to fund a portion of those funds ahead of the issuance of the bonds, recognizing the importance of providing those funds to the areas that needed them.
So
ahead
you
of
would
the
agree
abandonment.
that,
Excuse me.
so you would agree that for the ETA to accomplish its purpose of providing transition funding to impacted communities, that funding needs to be available at or around the time of abandonment when the plant closes.
I can't speak that it would need to be to accomplish those goals. Like I said earlier, PNM identified that it would be beneficial to provide those funds ahead of abandonment. However, the ETA, I don't think actually specified other than those funds should be made available 30 days after the issuance of the bonds.
Would transition funding be meaningful 10 years after the plant closed?
I can't speak to, excuse me, I can't speak to after 10 years, but I guess I will say funding for those who need it at any time is beneficial. But once again, PNM is not proposing to fund it 10 years after. I can't remember what you said 10 years after of, but that's not what PNM is proposing.
No, I understand that. I'm asking you if it makes sense for transition funding to be provided years after the transition.
And I guess what I said was,
It doesn't, right?
I'm sorry. What I said was, is that I think transition funding is always beneficial to those who need it. And once again, PNM is not proposing to fund it years after the event happens, in this case, the abandonment of the plant.
30 years after abandonment, is that helpful? I mean, come on, let's get real here. Transition funding is needed at the time of transition, right?
Mr. Hearing Examiner, this is becoming redundant and also argumentative. I object on that grounds.
Go ahead and answer the question, Ms. Monroy, and let's move on.
Like I said, Pnm's plan is to provide the funding to the impacted communities at the abandonment and is not impacted by the timing of the issuance of the bonds.
And that willingness of P&M to advance those transition dollars prior to the bond issuance, that's voluntary. That's a voluntary commitment by P&M, right?
I believe, yes. I know we did ask to provide 25% of the funding by, I think it was January of 2021. I believe that date was withheld while the ETA was under appeal. Once the appeal was then, either way, once the ETA was upheld, P&M did meet with the agencies to discuss providing the funds. And at that time, the agencies requested that the funds be provided at abandonment.
And P&M volunteered to accommodate that request, right? That was my question.
Oh, I apologize for interrupting you. P&M did agree to that.
Thank you. Now, P&M's position in this case is that the company has the discretion to issue the bonds whenever it wants, right? Even if that's months or years after abandonment.
P&M's position is that P&M is able to control the timing of the issuance of the bonds, and P&M now estimates providing issuance of those bonds near the end of 2023 when rates go into effect from our next general rate case.
Thank you. So let's say the company was not so altruistic and was unwilling to advance transition funds to the time of abandonment. If that were the case, P&M's position that it could issue the bonds years after abandonment would essentially provide transition funding at a time potentially years after transition, right? And that would defeat one of the purposes of the ETA, right?
So there were a lot of questions in there. I think you're asking me a hypothetical if P&M were not providing the funds earlier. I do believe the ETA is clear in that those funds would be provided 30 days after the issuance of the bonds. And so that would be the intent of the Energy Transition Act.
So, but for P&M's voluntary willingness to advance transition funds, P&M's interpretation of the required timing of the bond issuance could result in no transition funding being available for potentially years after abandonment. Is that right?
I think that's an interpretation of the ETA that, based on my reading, that's what the ETA prescribed. Like I said earlier, the ETA did not contemplate earlier funding.
Mr. Monroy,
and so
I asked you a simple question about whether or not, but for P&M's willingness to provide transition funding, the result could be that transition funds would not be available until years after a plant is abandoned. Yes or no? Is that right? You can explain your answer after you answer, but I would like an answer.
I guess in your scenario, you're saying if the bonds are issued 2 to 3 years later, then under the ETA, those funds will be provided 30 days after that date.
Yes, but for P&M's voluntary willingness to advance those funds.
Correct.
Okay. So the company's interpretation of how the ETA works could result in transition funding not being available for years after a plant is abandoned, right?
I would agree with that. Like I said earlier, that's why P&M identified that in our original application.
Now, you have posited that ratepayers are better off with P&M's strategy of delaying the bond issuance in the rate case because P&M's revenue deficiency will exceed the benefit of removing San Juan from rates. Is that a fair characterization of your testimony?
I believe that's accurate. Yes, sir.
Now, I'd like you to assume that P&M had not made any new investments and that its revenues were sufficiently covering its costs right now, and that all the San Juan replacement power could be recovered through P&M's fuel clause. You with me?
Your assumption, okay. I might not remember you basically that we never invested any more dollars. And what was your last thing you wanted me to assume?
There's no new net rate base, no additional net rate base. Your revenues sufficiently recover your costs, and that replacement power for San Juan could be recovered through P&M's fuel clause. Okay?
Oh, okay.
Now, P&M's position would still be that it is legally authorized to issue bonds well after the date of abandonment. The company's legal position with those assumptions would not change, right?
Yeah, I don't see how the two are tied to each other, right? But go ahead.
Okay. So in the example I just gave you, upon abandonment, the company's annual earnings would grow by roughly $98 million because that, or whatever the cost removal is, because that's the level of cost that would be gone, but the revenues would be preserved. Did you follow that? If not, I can restate it.
I think I'm following you.
Okay. So in that example that I gave you, or in that hypothetical, if the company exercised what it claims to be its legal right to delay the bond issuance, San Juan would be removed from its costs. So all the costs of San Juan would be removed from the company's cost of service, but there would be no revenue change, right? In other words, the company would enjoy extraordinary earnings by the amount of those costs that were removed from P&M's cost of service.
No, I disagree with that. And I can give you why, even under your hypothetical, that wouldn't work. If you removed, as we just talked about, San Juan's costs have gone from 98.3 to 58.7. The delta of that number is north of $35 million. P&M has an earnings test in place. And so if P&M were to have all, in your scenario where everything else, there are no new investments went in, our revenue stayed constant, but our costs in effect went down by $35 million in that instance, the earnings test that's in place by the commission would kick in and customers would receive any excess revenues, the over 50 basis points of our allowed return, and would be returned back to customers. So no, I don't agree with your hypothetical.
And the allowed
Mr. Michael, about 4 minutes.
Mr. Medeiros, this is going much slower than I anticipated. I'm not going to assign, blame for that. The answers have been long. And if it's acceptable to you, I would ask that we be allowed an additional 20 minutes that we would take from our cross-examination of Ms. Sanchez.
Yes.
Okay.
And
thank you.
My thinking on this is, in giving you those 20 minutes, that you will use the 20 minutes with Mr. Monroy now, and then we'll take the break, our morning break afterwards. Can you go for another 20 after this? Mr. Monroy, are you okay with that?
Yes, sir, I'm fine.
Okay. Is that all right, Mr. Michael?
Yes, it is. Thank you, Mr.
Okay,
Medeiros.
I'm adding 20 minutes then and taking it away from Ms. Sanchez.
Thank you.
You're welcome.
The earnings test that you described is a snapshot, right? It doesn't substitute for a general rate case. Would you agree with that?
Yeah, the earnings test provides a look back on the prior year's revenues and actual costs and allows for if P&M earns greater than 50 basis points, those amounts will be returned to customers in a subsequent year through the renewable rate rider.
And the rate of return would be 9.575%. That's the trigger rate of return.
It's 9.575 plus 50 basis points.
Right.
So 10.075.
Okay. And P&M's authorized ROE was set in 2016, is that right?
The case was filed in 2016. The rates were approved and went into effect in February of 2018.
Okay. Has P&M ever refunded any dollars to customers pursuant to that provision that you described?
No, sir. P&M has not earned greater than 50 basis points above its allowed return in any 1 year since that earnings test was put into place.
And if the commission ordered P&M to refund monies pursuant to that earnings test, would P&M accept that?
Yes, it's an approved order it's already an approved tariff and approved order. So the commission wouldn't have to order P&M to do anything.
And how many dollars of earnings are associated with 100 basis point ROE?
How many dollars are assumed?
In other words, how much would P&M's earnings need to exceed an ROE, its authorized ROE?
Subject to
Let me
check.
try it a different way.
Oh,
Sorry.
How many
one at a time,
dollars
please.
equates to 100 how many dollars equates to 100 basis points of ROE?
Yeah, subject to check. What's in my mind is I always think of like approximately $2 million of pre-tax is equal to 10 basis points. So then 100 would be 20 million.
20 million.
Yeah. That is correct. That is correct because I believe in my rebuttal testimony, the impact of if the rate credit is implemented of $98 million, that will preclude P&M the ability to earn a slot return by approximately 500 basis points. So yes, sir, about 20 million for 100 basis points.
And is that pre-tax or after tax?
That's pre-tax. The 20 million is pre-tax.
So assuming that the 12-0007 filings are correct and reflective of the company's true cost of service, the company could earn up to 10+% ROE without refunding any dollars to customers. Is that right?
Yes, sir. That's how the earnings test was designed.
And if those earnings were caused by a delay in the bond issuance, that would be those dollars could be kept by the company, right? And ratepayers would be deprived of those additional dollars up to that 10+% ROE.
I'm not understanding why it was tied to the delay of the bond, so I don't understand your question.
The delay of the bonds enabled P&M to earn more money than it otherwise would, the company, even under the scenario you suggest, would be able to keep those dollars up to a certain limit, presumably 10+% ROE, right?
Oh, I understand what you're saying. Yes, I mean, the delay of the rate case and the delay of the bonds allows PNM to defer any changes in its rates until those things are implemented. That is correct. I don't know if it relates to an earnings test, but.
On page 13, you indicate that the company, by your numbers, would have a deficiency, revenue deficiency going forward of between 23 and 36 million. You recall that testimony?
Yes, sir.
Okay. And is that based on your existing 9.575 ROE?
Yes, sir, it is.
Okay. Are you aware of PNM ever having sought a rate increase that was not contested?
Not to my knowledge.
Okay. Are you aware of PNM ever obtaining a commission order in a rate case that accepted the company's claimed revenue deficiency?
I'm sorry, could you ask that question again? I'm not sure what.
Has PNM ever gotten what it asked for in a rate case?
Not to my knowledge.
Okay. So from the standpoint of regulators, PNM always overstates its revenue deficiency. Would you agree?
I would not agree with that statement.
I thought you just did, but we can move on. Would you turn to page 32? And there you say that PNM will file its next rate case in December 2022. Is that a certainty?
That is the current plan of the company.
Okay, and those companies' current plans for rate cases haven't been achieved, at least recently, right?
As I've laid out in my testimony in this case, the timing of PNM's next rate cases have changed.
So it's possible that December 2022 date could slip and PNM not file a rate case at that time?
It is possible. It is, but that is
Okay.
the current company's estimate or intention to file a rate case.
And is it possible that that date could be delayed by years? Is that possible?
I would think it's highly unlikely. I also think it's highly
But it's
unlikely
not.
that this case would not be delayed either.
But it's not impossible.
Well, given where we are now and having gone through a global pandemic, I can't say anything's not possible anymore.
Okay. So in your rebuttal on page 6, and you say the financing order only requires the rate credit be provided when the energy transition charge goes into effect, right?
That is correct.
Okay. And the energy transition charge goes into effect when the bonds are issued or shortly right after the bonds are issued, right?
That is correct.
Okay. And your testimony is that the financing order does not require the rate credit to go into effect upon abandonment, right?
Correct.
Okay. Would you agree that if the financing order required PNM to issue the bonds upon abandonment, then whether the rate credit occurs upon financing and energy transition charge or upon abandonment is really a distinction without a difference? Did you follow my question?
I didn't. I guess I would agree that. Oh, go ahead. Sorry, if you want to ask again.
Sure. What I am saying is you have said the rate credit goes into effect with the energy transition charge, not with abandonment.
Correct.
And my question is, if abandonment and bond issuance are to occur at the same time, then whether or not the rate credit goes into effect with abandonment or with bond issuance is a distinction without a difference, because those two events occur at the same time, have to occur at the same time. Do you follow that? No.
Yeah, I guess my answer would be that that doesn't change my answer, in that the rate credit as approved in the financing order would need to go into effect upon implementation of the energy transition charge. I don't think it is not tied to abandonment.
But if the financing is tied to abandonment, then the date is the same or very close to the same, right? In other words, if you have to finance at the time of abandonment, then you have to provide that rate credit at the time of abandonment too, right?
Yes, if the bonds were required to be issued at abandonment, then I agree with your premise that then the credit would go into effect. However, PNM does not believe that the ETA requires the issuance of the bonds at abandonment.
I understand the company's position.
Okay.
Now, on page 7, you refer to the commission order that allowed PNM to extend the abandonment date of San Juan by 3 months. You recall that testimony?
Yes, sir.
Okay. And you say that this order confirmed that the financing order does not require bond issuance at any specific time. Would you agree that the reason the bond timing issue came up in that context was because PNM was going to delay the abandonment?
So I wouldn't care. I don't know why the commissioners included that in there. I know that was an order and where PNM was requesting the ability, if necessary, to keep San Juan Unit 4 open for an additional 3 months.
Okay. Isn't it conceivable that what the commission was saying was that because there is no date certain for abandonment, there is no date certain for bond issuance?
I can't speak for the commission. I know what the thing says in paragraph 26. And it says, likewise, the terms of the commission's April 1, 2020 final order on request for issuance of a financing order adopted the terms of the February 21, 2020 recommended decision on financing order, which in turn does not require that PNM issue the energy transition bonds authorized by that order by any specific date. And so to me, it's referring to the financing order and the final order in this proceeding.
Okay. So my question was, is it conceivable that what the commission was saying was because there's not an absolute date for abandonment, there's not an absolute date for financing, but nowhere is it correct? Am I correct that nowhere in that order does the commission say the bond issuance is not to be linked to the abandonment date?
Well, I believe I just read what that order says, so it does. That's exactly what it said.
Okay. And you're not aware of anywhere in that order where the commission says bond issuance and abandonment are unlinked? In other words, that one doesn't trigger the other. The abandonment doesn't trigger the bond issuance. We can move on. The order is going to speak for itself. So on page 9 of your rebuttal, okay, you dispute the notion that there's a double recovery from Pnm's delay strategy, right?
Yes, sir. I believe the double recovery, as referred to by the ETA, is appropriately addressed through the rate making mechanisms that were approved in the financing order.
Okay. So let's move forward to post-abandonment and assume P&M has a regulatory asset on its books to recover the capital costs of San Juan, okay? Does that make sense?
I follow. Yes, sir.
And then P&M files a rate case and assume P&M is allowed to recover those same capital costs in its rate base, along with the regulatory asset. Would you agree that in that situation, P&M would be recovering those same capital costs twice? Once in base rates, and again, as it recovers the regulatory asset?
So the regulatory asset I thought we were talking about was the related to the energy transition costs related to the undepreciated investment. And
yes.
There's no scenario in which we would include that regulatory asset in our next general rate case, as that will be securitized when P&M issues the bonds and will become energy transition property of the SPE. And so it wouldn't be included in P&M's general rate case.
So if P&M is able to recover the cost of that regulatory asset through a bond issuance, the obligation of which is on customers, and is also able to recover the capital costs of San Juan in a rate case, in a future rate case, would you agree that those costs are being recovered from customers twice? Once through having to pay off those bonds, and secondly, through the inclusion of those capital costs in base rates?
I guess I would say that wouldn't happen because under the financing order, once the energy transition costs is recovered through the energy issuance of the energy transition bonds, and that charge becomes effective, customers will receive an interim rate credit if the base rates still reflect costs associated with San Juan. And so I don't think that what the scenario you're explaining is possible.
You're changing my hypothetical.
Yeah. That Mr. Monroy, even I picked that one up.
I guess I don't understand you, but the hypothetical of including San Juan in our next rate case, even though San Juan is abandoned, I guess I don't, that doesn't make sense to me.
5 minutes,
Doesn't
Mr.
make
Michael.
sense to me either.
5 minutes.
That's all. Thank you, Mr. Hearing Examiner. Yeah, it doesn't make sense to me either. That's the point of this case. Could you turn to page 18 of your rebuttal? And you testify that parties requested as part of the merger proceedings that P&M propose its next rate case until the end of this year, December of 2022, right?
Yes, sir.
Has any party ever requested that P&M postpone the bond issuance beyond the abandonment date?
Not that I'm aware of.
Okay. Would you turn to page 24 of your rebuttal? And there you dispute the notion that rates will be unjust and unreasonable unless a rate credit is provided. Would you agree that the ETA and the financing order lock in the plant balance for San Juan units 1 and 4 as of the date of recovery? Or I'm sorry, as of the date of abandonment for recovery through a bond issuance?
Yes, yes.
Okay. And there are no other assets on P&M's books that can be preserved with that same legal protection and legal requirement, right?
I believe the ETA is specific and provides the necessary qualifications for that accounting treatment to be provided. And so I think there's for the San Juan, and I believe P&M made a similar request in the Four Corners abandonment and financing order.
So those legal constraints and legal protections are unique to the San Juan and Four Corners coal plants, right?
For P&M, those are the two that would qualify.
Okay. In other words, the ETA established a new and different cost recovery protocol for coal assets like San Juan Generating Station, right?
Yes, that's the ETA provided for how to handle upon abandonment the energy transition costs.
And that's different than other assets on P&M's books. It's a different protocol for cost recovery than for T&D or non-coal plants or renewables, right?
That's correct. Yeah, it was specific to what the ETA mandated.
Mr. Hearing Examiner, if I could have, I guess I've only got a minute, if I could just have a few seconds to review my notes, I may be done.
Sure.
I think that's all I have. Thank you very much, Mr. Monroy. I appreciate your testimony.
Thank you, Mr. Michael.
Okay, thank you, Mr. Michael. Let's take a 15-minute break and be back at around 10:47 with the next cross-examination. So we are on break now until 10:47. Thank you, Mr. Monroy. Thank you all.
Mr. Medeiros, I am going
Yes,
to
sir.
leave the meet. I'm going to leave the
All right.
meeting, and you would admit Ms. Beatles. That would be great.
Yes, I have one question though. Mr. Monroy, we're on break. One of the exhibits, the SC2, it was a cross-examination exhibit, but I don't think it was labeled, was it? I admitted it, but I'm looking at it and I don't think it was labeled WRASC-. Did you check on that during the break and have Ms. Beatles address that if I'm mistaken? But I downloaded it, that particular document, and I don't think it was labeled. If I'm mistaken and downloaded the wrong thing, forgive me, but just please have Ms. Beatles or you check that at the break, which we are on now, but we're about to go into. But Ms. Lynch, yes?
I'm just requesting that you also let Stephanie Zur in.
Yeah.
Okay.
Yes. Yeah. And Mr. Albright, did you have something?
I think you may have addressed it, Mr. Hearing Examiner. I just wasn't sure that all of the documents had been moved into evidence that Mr. Michael had referred to. But
Yes,
he didn't check. He didn't seek the admission of the long-range plan, which was redacted in part and was not marked as well, I believe.
Thank you, sir.
Well,
but he didn't seek the admission of that one.
Yes, I will. If we could, we'll do both of those when we get back from break. We'll see. Thank you,
Okay,
Mr. Albright.
and this goes to everyone. Please be sure to mark as in the first, at least the first page, prominently, whatever the name of the party is, SC dash whatever the number is, please. Okay, we're on break now. Let's come back at 10:48, just before 10:50. And Ms. Gonzalez?
Yes.
Would it be, I didn't ask for it, I just assumed, but do we have real time available? Maybe.
I have to set that up. I don't think that was requested.
Well, no, I didn't request it. I just assumed in hearings like this that we use it, but can we maybe after lunch or later, if it's convenient? If not, tomorrow morning would be fine too for that. But I do miss that security blanket.
Sure.
But and I'm sorry I didn't request it. So
that's okay. I probably should have asked and I didn't even think about it.
Okay, thank you.
All right, thank you.
Okay, we're on break now. I'm, before we start, I'm just, okay. Good morning. We're back from our morning break on the first day of this hearing. Ms. Zer for CCAE, are you ready for your cross-examination of Mr. Monroy?
Yes, sir, I am. Before I start, I could give him a preview of what documents I'm going to need him to pull up just to make things move along a little bit more quickly, if you'd like me to do that.
Yes, ma'am.
Okay, Mr. Monroy, I would
Mr.
ask.
Medeiros.
Yes, sir.
I'm sorry, I didn't want Ms. Zur, didn't want to interrupt in the middle of what you're doing. At the end of the prior session, realized, thanks to Mr. Albright, that I neglected to move the admission of exhibit WRA-SC4. And I would like to do that and then also address your request that the exhibits be specifically labeled. But
well, why don't we start with that?
Okay.
Why don't we start with the labeling? Why aren't they, are they labeled, or did I?
We are. So, Mr. Medeiros, we discussed that over the break, and what we intend to do is we cannot, I don't believe, remove documents that have been uploaded and edit them and then re-upload them. What we are planning to do, or going to try and do, is upload duplicate exhibits, each of which will have a cover page with the exhibit number on it. And then we will delete the initial 6 exhibits. The exhibits will be exactly the same, but for the cover page that would be added to each of them. Okay. And we're working on doing that as quickly as we can.
All right, thank you. But now then, getting.
Yes, I was just going to move the admission of exhibit WRA-SC4.
That SC4 is a redacted document that's redacted, correct? Is that the correct version of the long-range plan that you want admitted?
Yes.
Okay. Any objection to the admission of WRA-SC-4?
No objection.
WRA-SC-4 properly labeled is admitted.
Thank you. I'm sorry to interrupt, Ms. Zur.
No, that's quite all right.
Go ahead, Ms. Zur. Yes, ma'am, okay. Please.
Mr. Monroy, do you have CCAE Exhibit 8?
Yes.
Okay, would you please read me the question and answer to NEE Interrogatory 228?
Ms. Zur, have you started your cross? I thought you were going to go through the documents first.
I was, are you going to, but I just jumped in after the interruption.
Oh, okay. Well, then I should start the clock.
I apologize. I switched gears.
That's all right. I haven't started it yet. Yeah. So I have you down for 60 minutes, 60, right? With
yes, sir.
Mr. Monroy? Okay. Yes. All right. We're starting now.
Thank you.
Please.
Mr. Monroy, could you please get CCA Exhibit 8?
Yes, ma'am.
Okay. And CCA Exhibit 8, do you recognize that as being NEE Interrogatory 228?
Yes.
Okay. And could you look at the bottom? What's the date of that response?
October 1, 2019.
Okay, could you read me the question and answer, please?
Question, please explain how securitization saves customers 22 million compared to traditional rate recovery. TR Settlage, page 27. Response, please see PNM Exhibit HEM-2 for the calculation of the $22 million savings. Also see page 5, line 2 in PNM witness Monroy's direct testimony for further discussion of the estimated 22 million savings in 2023.
Could you now pull up CCA Exhibit 9?
Yes, I have it.
All right, and this also, if you look at the bottom of the page, would you agree this is from 2019 as well?
Yes, August 13th, 2019.
Okay, and this exhibit is P&M's responses to AG 127. So if you would turn to the page where the question and the answer appears, could you please read me the question and answer?
Yes, question. Provide the total annual savings to customers by year due to the abandonment of the San Juan coal plant for the first 20 years after abandonment. Objection response. PNM objects to NMAG's interrogatory 1-27 on grounds that it requests the creation of information and documents which do not currently exist, contrary to the requirements of Rule 1-026 NMRA and Rule 1.2.2.25 NMAC. Subject to and without waiving such objection, PNM responds as follows. PNM has not calculated these amounts for any scenario after 2023. PNM has not calculated on-year forecasted future market sales and purchases, and therefore cannot calculate full revenue requirement impacts for 2024 through 2040 as shown on PNM table HEM-12. PNM has provided 2023 revenue requirement impacts for 2023 because this represents the first full year, which is typically the largest and most conservative revenue requirement.
And you don't see anything about this answer that refers to the savings in 2023 as being just an estimate, right? I'm sorry, let me withdraw that question. I think I'm going to ask my question again. There's nothing in here about 2023 being an estimate, right?
Not that I read.
I heard you say to Mr. Michael that you didn't recall the 4 events. And when we talk about the 4 events, I'm gonna call them the 4 events. I'm referring to the events after which bonds will issue, the issuance of a final non-appealable order, abandonment, delivery of necessary SEC approvals, completion of the rating agency process. So I'm going to refer to those to the 4 events. If we can agree to that, I won't have to repeat that whole thing every time. Okay.
Okay.
I heard you tell Mr. Michael that you didn't recall what the 4 events were. Is that right?
That's correct.
And have you not looked at that anytime recently to see what it said?
It's not coming to mind.
Was that ever discussed, to your recollection, these 4 events upon which bonds should issue by PNM in conversations, say, since January? Do you recall any conversations about these 4 events?
Nothing's coming to mind. No, I do not.
All right. Would you kindly open up CCAE Exhibit 3, what's been marked as CCAE Exhibit 3 for identification?
And Ms. Zur, I have to note, I'm sorry, but you have CCAE exhibits already admitted in the original proceeding. These were supposed to be labeled SC- to distinguish them from the original exhibits. And they're not labeled correctly unless I'm missing something.
You're right. They're not labeled SC. I think I missed that. And I could, during a break, I could go back and change all those. I know how to delete them and I really just missed that and I do apologize.
No, that's okay. And I'm not trying to be a stickler about it. It's just that to distinguish from your original exhibits in the case. That's why you are using the SC designation for them.
Before this goes to the court reporter for a record, I will make sure all that's corrected and I do apologize.
Thank you.
Mr. Monroy, do you have the application before you now?
Yes, I do.
Okay, could you please turn to page 23? I'm sorry, not 23. Page 34.
Yes, I'm there.
Okay, could you read me paragraph 53?
Paragraph 53 says, Section 4B7 of the Energy Transition Act requires that a qualifying utilities application for a financing order include an estimate of timing of the issuance and term of the energy transition bonds or series of bonds, provided that the scheduled final maturity for each bond issuance shall be no longer than 25 years.
Right above paragraph 53, could you read me that sentence?
Proposed timing of issuance and term of the energy transition bonds.
Now read paragraph 54 if you would.
As described in the testimony of Pnm witness Eden, the company expects to cause the issuance of the energy transition bonds as promptly as possible after the last of the following events have occurred. 1, issuance of a final non-appealable financing order acceptable to the company. 2, the abandonment of the San Juan coal plant. 3, delivery of any necessary Securities and Exchange Commission approvals under the Securities Act of 1933. And 4, completion of the rating agency process. The company currently estimates the issuance of the energy transition bonds would occur in 2022.
Do you see in that section anything about bonds will issue at the conclusion of a rate case? Is that in Pnm's application?
It's not in paragraphs 53 or 54. I do note it says the company currently estimates the issuance of the energy transition bonds would occur in 2022.
Mm-hmm. And what it was an abandonment occurring in 2022 also?
That is correct.
Are you aware that the 4 events are part of the financing order?
I'm sure that I don't know.
Okay. Are you aware the 4 events are in the recommended decision under the section describing the structure of the bonds? Do you know if that's in there?
I don't know.
Could you please pull up CCAE 11? And let me know when you have it before you.
Yes, I have it.
Okay, I represent to you, I got this from the New Mexico Compilation Commission, and this is the New Mexico NMAC, the commission's rules for pleadings. And I think I'm going to read this one to you this time. Pleadings shall be in writing, shall state their object, and shall be signed by the party or staff representative seeking authorization or relief from the commission or by their attorney. Contents, all pleadings shall be paginated and shall contain a clear and concise statement of the authorization or other relief sought. And I'm going to skip down to the third paragraph. A concise and explicit statement of the facts which said party or the staff is prepared to prove by competent evidence and upon which the commission is expected to rely in granting the authorization or other relief sought. So based upon this rule for pleadings, is it your understanding the commission had a right to rely on Pnm's application, and specifically paragraphs 53 and 54 for the timing of bond issuance?
Mr. Hearing Examiner Rick Alvidrez, I have a couple of objections. One is foundation. This witness isn't a lawyer and is being asked to give a legal opinion about pleading rules. And the other is, I don't think that this is a full statement, or we have not been provided all of the rule that's referenced here. It appears to be just a partial.
That's the whole thing.
Is it?
Yep.
Well,
I'll withdraw my question rather than waste the time. I'm happy to go on if that's okay, Mr. Alvidrez.
Okay.
Please
All right.
proceed.
You say on, you don't have to turn to this. I'm just going to ask you a question. I don't think you're going to have to refer to your testimony. But you say on page 17, Pnm provided its good faith estimate that it would issue the bonds near the time of abandonment. What do you mean by good faith estimate?
Based on the information that we knew at the time. If you're referring to, I apologize since you didn't, I assume in my direct testimony I say that, but I'm referring to that was the information we knew at the time when we requested the financing order.
So are you saying that as long as it was true at the time you said it, is that what you mean by good faith? I'm trying to understand. I mean, you used the words.
Yeah, that was the information we had at the time we made the application.
So okay. Does Pnm also have to act in good faith to comply with the terms and conditions of the financing order?
I would agree with that.
And I think you refer to those 4 conditions in Pnm's application as only an estimate. Only an estimate. What does that mean?
Can you point to where I'm talking about? I'm a little confused on what exactly you're referring to.
What's this? Let me just ask you then, what do you think the significance of your estimate in your application is? Because you say Pnm can issue the bonds whenever it wants. So what's the significance of that?
So under the ETA, one of the requirements in the financing order, and I don't have the exact site, so I apologize, but I think I read it in there, required that Pnm provide an estimate of the estimate and timing of the bonds or something of that nature. And so it was a requirement under a financing order for Pnm to provide its estimate of when those bonds would be issued.
And that actually the ETA says Pnm shall provide that estimate, right?
Subject to check, I believe you. I don't know the ETA that specifically.
And what was the estimate? It was those 4 conditions, right?
I believe the estimate was to issue the bonds in 2022. I think it was that last statement on that paragraph I just read.
Okay. Was that estimate wrong?
It has changed. I don't know. It wasn't wrong.
Well, by wrong, I mean, was it incorrect?
No, it was an estimate.
Well, what's changed?
So I go through that in my direct testimony where I talk about what has changed from that. And I guess I would point you to my direct testimony. You want me to read that to you or?
Not really.
Okay.
Okay, so basically the things you say in your direct testimony, that's what's changed. COVID, rate case, timing and all that, right?
That's correct.
Okay. So the timing of your rate case, you've already told me, is not one of those 4 events that has to occur for issuance of bond. So why do we care? Why does that matter if you've filed a rate case or not?
Why does that matter relevant to what?
to the 4 conditions in the application. You told me that timing of a rate case is not part of your application, and that wasn't approved as the timing of the issuance of the bond in the financing order. It once again lists those 4 events. So why should the commission care if you filed a rate case or not? What does that mean?
So I guess a couple of things. I'm not sure if the timing of the rate case is in the application. I'm not sure if I said that. It was in my direct testimony that we filed along with this case, where we indicated our intent to file a rate case to coincide with the issuance of the bonds, as well as with the abandonment of San Juan. And so, whereas if it's not in the application, it definitely is in my direct testimony that was provided to the commission in this case. And then I apologize. What's your other question?
I don't have another one. Could you please pull up CCA E10?
Okay. I'm there.
Okay, and if you'll scroll down to the question, 3 point, let's once again, when was this responded to by PNM?
September 9, 2019.
And this is PNM's objections and responses to AG's 3rd set of interrogatories, correct?
That is correct.
Okay, read me the question and answer, please.
For each and every requirement of the Energy Transition Act for the issuance of a financing order, especially as set forth in Section 4 of the ETA, please provide the testimony and page references for each witness that addresses the requirement.
I'm going to stop you. I don't want you to read the whole table. Could you please scroll down to where it says ETA 4B7 and read that line?
ETA 4B7, application for a financing order, shall include an estimate of timing for issuance and term of bonds, final maturity no longer than 25 years. Application page 34, Eden, pages 14 through 16.
Okay, so the question asked PNM for every requirement of the Energy Transition Act for the issuance of a financing order, please provide the testimony and page references for each witness. And PNM identified the application at page 34, and that's what we just looked at, paragraphs 53 and paragraphs 54. Is that correct?
I believe you that was the page 34 I read from.
And would you also agree that that line that you read, ETA 4B7, does not say anything about the filing of a rate case, the conclusion of a rate case, right?
I agree that 4B7 does not talk about a rate case, that it requires that it shall include an estimate of timing for issuance and term of bonds.
And could you do me a favor now? I want you, we don't normally do this, but let's look at the affidavits here, okay? I'm scrolling down and I'm going to start with the affidavit on page, let's see, the first one is Charles Atkins.
Yes, I'm there.
The next one, Elizabeth Eden, interrogatory 3-3. The next one is Tom Falgren, interrogatory 3-3. Henry Monroy, 3-3.
Yes.
Let's see, Mike Settlage, 3-3. These are witnesses testifying in this case, right?
That's correct. Or, I mean, Lisa Eden and, or I'm sorry, I don't know what case you're referring to, but.
Okay. So, I've got a very small screen here and I'm manipulating things, so I apologize for my lag here. So Elizabeth Eden's not on there, right? But you notice that all of the witnesses in that response did what? They pointed to Elizabeth Eden's testimony, right? So let's go look at that response again. You see that? It said page 34 of the application. And it also said what? Can you look at that line again?
Yes, pages 14, or Eden, pages 14 through 16.
Okay. And I will represent to you, you can go confirm that. I don't have Miss Eden's testimony, but it was the same thing that paragraphs 53 and 54 say, the 4 events once again. You remember you were a witness in the Four Corners case too, right? 21-00017.
No, I was not.
You weren't a witness? Okay. All right. You understand the commission relied on the information provided by P&M in its application?
I understand that the commission made its decision based on the evidence presented at hearings and filed in testimony.
Do you understand that the commission relied on P&M's application?
Yes, I would hope so.
And do you also understand the commission has a right to rely on that?
Yes, I believe that's correct.
And do you understand that all the interveners in the case also relied on that information when they prepared their own responses to P&M's testimony and application, right?
Yes, I assume that's what they relied on.
So, Henry Monroy, I'm sorry, Mr. Monroy, I'm referring you to someone else. I'm sorry. I got a lot of notes here. You have HEM 3, which is an exhibit to your response testimony where you cite all the places in the record where P&M informed the commission of its intent to file a rate case. And you can refer to that if you'd like. Because my question is, do any of those refer to it being in P&M's application? Concurrence with the rate case?
In P&M exhibit HEM 3, no, I believe they refer to the financing RD, citations to evidentiary record, and then the hearing transcripts.
I would like you to turn to page 7 of your rebuttal testimony, sir.
Yes, I'm there.
Page, let's see, 37, line 5. Does the financing order require P&M to issue the energy transition bonds at the time of the San Juan abandonment as claimed by staff? And your answer, no, staff cannot point to any express language in the financing order that requires bonds be issued at the time of abandonment. I asked you a minute ago if those 4 events were in the financing order, and you told me you didn't know. Right?
Correct.
Okay. But now you know that's in there.
You quoted me 4 paragraphs of an RD. What I'm saying here is there's no language in the financing order that requires the bonds be issued at the time of abandonment.
The
those four events do not require the bonds to be issued at the time of abandonment. The ETA required P&M to provide an estimate of when the bonds would be issued, of which P&M did. And so we complied with the requirements of the ETA, and on which the commission then issued a RD and ultimately a final order on the financing order in this case, based on that estimate.
Okay, so is it safe to assume that you don't believe that estimate's binding on P&M, right? That doesn't mean anything?
Estimates are what they are. They are estimates, and that's the best information that's available at the time.
Mm-hmm.
And as we say here, the financing order does not require the bonds to be issued at the time of abandonment. And I believe P&M witness Ms. Sanchez also goes into further detail on this topic.
Do you have a copy of the ETA?
I do. Yes.
Could you please turn to section 8? Aggrieved parties request for rehearing judicial review.
I'm there.
Okay. And if you go to the paragraph B under that, and I'm going to read it to you. An aggrieved party may file a notice of appeal with the Supreme Court in accordance with section 62111 NMSA 1978, provided such notice shall be due no later than 10 calendar days after denial of an application for rehearing, or if rehearing is not applied for no later than 10 days after issuance of the financing order. The Supreme Court shall proceed to hear and determine the appeal as expeditiously as practicable. And so I will represent to you the normal time for notice of appeal is 30 days. It has in here that it is now 10 days. So that takes 20 days away from the time an appellate would normally have to file a notice of appeal. And then it goes on to say, once you get to that appeal, the Supreme Court shall proceed to hear and determine the appeal as expeditiously as practicable. Does that indicate to you that there is a sense of urgency?
Mr. Hearing Examiner.
Statute?
Mr. Hearing Examiner, I object. The question was quite compound. Ms. Zur didn't read the section B entirely accurately. She left out a word.
Can I withdraw my question? I'm sorry, I don't want to waste time. I'll just move on if you have an objection, sir. All right.
Next question.
You state on your testimony on page 7 that the ETA provides flexibility. You start talking about flexibility. Other parts of the financing order contradicts staff's position that Pnm's required to issue the bonds at the time of abandonment and confirm that Pnm has a great deal of flexibility with respect to the issuance of bonds. Now, Mr. Alvidrez just objected a while ago that you're not a lawyer, but aren't these legal opinions that you're offering here? That the financing order offers all this flexibility?
That wasn't my objection.
An earlier objection. All right, that's not a question. Let me just ask what you have here. All right, so I'm looking at line 18. Okay, so first you say the financing order confirms Pnm has a great deal of flexibility with respect to the issuance of bonds. For example, at page 63 of the financing order, it says, the ordering paragraphs afford Pnm the flexibility to establish the final terms and conditions of the energy transition bonds. Do you think that authorizes Pnm to ignore the actual time of bond issuance in its financing order? That particular provision, and issue bonds whenever it wants to?
I'm not saying that Pnm is ignoring anything in the financing order. I'm saying that the financing order does not require that the bonds be issued at the time of abandonment in this Q&A.
You have 3 different things you cite to support this argument that there's flexibility in the financing order. So my question is simply, do any of these 3 parts of the financing order that give you flexibility state that you have flexibility to issue the bonds whenever Pnm wants to?
I think they say exactly what they say, where they say the ordering paragraphs afford Pnm the flexibility to establish the final terms and conditions of the bonds. That in the second one, they shall be afforded flexibility in establishing the terms and conditions of the bonds. And then the final paragraph 24 provides that Pnm has the discretion to issue and sell the bonds in one or more series consisting. And I guess I would also point out in the Q&A above that on lines 11 through 16 that point to the commission stating in the final order that does not require that Pnm issue the energy transition bonds authorized by that order by any specific date. And that was, I apologize, the order not in this application, but in Pnm's request to extend San Juan Unit 4.
Well, let's talk about specific date. And sometimes you call that a date certain, right? And I can't point you to a specific page. I'm just going to ask you a general question, all right? You and Pnm witnesses have repeatedly said the ETA does not require a date certain for abandonment, right?
The ETA didn't required an estimate of when the bonds would be issued. That's
Okay,
what
but
was
you-
required in a financing order. Yes.
Okay, and it doesn't say you have to provide a date certain, right?
No, it provides an estimate.
Okay, and your application, those paragraphs we talked about, it said bonds would be issued after the latest of these 4 events. So it didn't provide a date certain, right?
I don't remember if it said that the latest of these events, but I did read it in there. I said that it included the estimate of that would be in 2022. And I pointed out in my testimony earlier in this case that we also estimated a rate case to go into effect at the same time of abandonment, at the same time we were planning to issue the bonds.
Yes, but we already discussed that part about a rate case isn't in your application, right?
I said it's in my direct testimony, which was part of the evidence in the case.
But it's not in your application, right?
No, not that I'm aware of.
Okay. All right, so all right, I think we've acknowledged that the date you were talking about still wasn't, did P&M never said it's going to issue bonds on July 1st, 2022 or whatever. That was never your plan. You never provided a date certain. No, we're not arguing about that, right?
I'm not sure I understand your question.
Well, I guess I don't understand your arguments. All the P&M repeatedly refers the commission to the fact that neither the financing order or the ETA requires P&M to issue bonds on a date certain. So I'm trying to figure out why you think that's important. Why does that matter?
Well, here specifically, parties in this case have raised issues or raised claims that the energy transition bonds are required to be issued at the time of abandonment. And so we're providing testimony that disproves that that is not what the ETA says.
Is the time of abandonment a date certain?
No, I will say that was an estimate as well, has been borne out. We were estimating that San Juan units 1 and 4 would have abandoned at June 30th, 2022. And that has been an estimate that has also changed.
P&M's estimate wasn't a date certain. It was an event certain, right? 4 events. As soon as it is practical after these 4 events. That's why, right? There's no date certain required in the financing order or anywhere because the bonds were to be issued at the completion of 4 events, not on a date certain, right?
Objection compound.
Can you answer the question?
Go ahead, Mr. Monroy.
Okay. No, I disagree. I mean, the financing order, the P&M's application pursuant to the ETA required that P&M provide an estimate of the issuance of the bonds. P&M provided the estimate of the issuance of the bonds, estimating it to occur in 2022. And so that is what was provided in the application. That was what was provided in testimony. And that is what the financing order then acknowledged.
And the paragraph 53 and 54 you read, that's part of it too, right? Part of the time of abandonment in the application, recommended decision, financing order, that's in there too, right? That's the time of abandonment, right?
That was the estimated time. Yes, that was the assumption.
And when I said your estimate regarded event certain rather than a date certain, those events had to do with abandonment, correct? Yes?
I'm sorry, could you ask that question again?
The event that triggered the issuance of the bond was abandonment, correct? The event that had to occur?
The events that we contemplated was that San Juan plant would be abandoned and that P&M would implement or have a rate case that would reflect the changes in its cost of service. We estimated that to time at the time of abandonment as well. And we also estimated the bonds to be issued at that time also. That is correct.
I'm going to have you look at another exhibit here. If I can find it, sorry. CCA 24, could you pull that up, please?
Yes, I'm there.
Okay, this is a response to interrogatories provided by Pnm, correct?
It appears, it says May 13, 2022 supplemental, page 1 of 4.
Okay. On the to line of that, from sent to, do you see your name?
Yes, I do.
Okay, do you recall receiving this email? I'm sorry.
Yes, I got the email. I mean,
okay. So the top above the line appears to be a response to what's below it. So I'm going to go to where it says from Goodman Lisa. Who's Lisa Goodman?
She's our Director of Investor Relations.
All right. And I'm going to read the subject line, Securitization Comms Plan, in some letters and numbers. And the statement here, I didn't get to provide details in time, but these were my bigger thoughts. I still think somewhere we need to say the words that the San Juan savings were meant all along to be considered at the same time as a full rate review. I think we all have that in our heads, but we don't ever explain that to our audience. Then there's a reply, Eden Elizabeth, and who is that?
Lisa Eden is our Chief Financial Officer and Treasurer.
Is that the same Lisa Eden who testified in this case and provided the 4 events upon which bonds, your estimate for the time of bond issuance? Is that the same Lisa Eden that provided that testimony?
Yes, that is the same Lisa Eden who's provided testimony in the earlier part of this case.
And that's the same Lisa Eden who 5 Pnm witnesses swore under oath that the parts of Pnm's application on time of issuance of the bonds, that 6218 4B7, that's the same Lisa testimony from Lisa Eden. I'm sorry, that was a terrible question. Let me just move on. All right, so I think we've established that Lisa Eden is the same person who everybody pointed to as the witness on time of a bond issuance, right? Yes.
Yes.
Right.
Yeah.
Okay. Sorry to make that so difficult.
That's okay.
All right. So what I want to ask you about is this statement here.
Was that the question?
No. I still think somewhere we need to say the words that the San Juan savings were meant all along to be considered at the same time as a full rate review. I think we had that in our heads, but we don't ever explain that to our audience. And so what I want to ask you about is this idea that Pnm representatives seem to all have it in their heads that the time of bond issuance is at the time of a rate case rather than what the application says.
So I mean, you're referring to an email that was written in 2022 that was commenting on a communications plan. That has nothing to do with what was provided in our application and direct testimony, where it was clear in our application and direct testimony, in my direct testimony, our plans are regarding the rate case and the timing, and that they were synced up, that they were all expected to happen at the same time. Here, these comments are referencing what was in this securitization communications plan and whether it was explicitly stated within that communications plan.
Okay. Tell me about the securitizations communications plan, would you please? What was that all about?
I'm trying to recall, I believe it was a plan that was being developed by Ray Sandoval, and able to communicate both regarding the extension or the change in plans for the abandonment date of San Juan Unit 4, as well as communications regarding Pnm's next rate case, as well as regarding Pnm's timing of issuance of the securitization bonds.
So were you aware of the survey that Pnm sent out to its customers to find out what they thought?
I have seen the survey results and discovery that was provided because I looked through all the discovery.
Okay, had you never seen the actual survey before?
No, I had not.
I'm going to go back to CCAE 12. So you all are discussing communications about these various, what can we refer to, what do you want to call it? I don't want to keep having to go through every time I ask the question, but events that were coming up. You're having communications about all these upcoming events, right? I'm just trying to come up with a way that we can agree to refer to this.
Refer to what?
All right, I'm going to call it the communications plan. All right. All right. Now, CCAE 12, if you'll go, you'll see there's an email from Tom Falgren. And it was to Elizabeth Eden about, and again, the subject line is the draft communications plan.
I apologize. My CCA 12 is Pnm's response to CCA's 14th interrogatories. Is there an email?
1416.
14.6.
Do I have the?
Maybe it's
the response to 1416, right? Okay, you're CCA 15.
Okay.
Yeah, you're right. 12 is the responses, 15 is the attachment.
I would note that there are two CCA 15 exhibits.
There are?
There are.
All right. Do you have CCA 15 Pnm exhibit CCAE 14.6? I don't have two in my Dropbox. That's so weird.
They're labeled as there's two exhibits labeled as CCA 15.
Where?
Well, I have one that says Pnm. It says CCA 15, Pnm exhibit CCAE 14-3 paren capital F close paren. And then I have a separate CCAE 15 Pnm exhibit CCAE 14-6.
I only have one. I don't know what you're talking about. But I'd like to go on with my cross-examination, if that's okay. Mr. Monroy, do you have CCA 15? CCA 15?
Yeah, mine it says CCA 15 Pnm exhibit CCAE 14-6, and it looks like it's an email from Leslie Padilla, or Leslie Padilla is at the top of it.
Okay. So if you will look halfway down that first page, you'll see an email from Tom Falgren.
Okay, from Tom Falgren to Ray Sandoval, Ron Darnell, and Lisa Eden was copied.
Yeah, I'm going to read you his comments, and I'd like to ask you a question about that, okay?
Sure.
All right, so you'll see it says, sorry, I haven't been part of the detailed discussions, so a little behind on the details of what our plans are. Seems we are delaying securitization to align with the next rate case. Generally the same idea here as we previously presented, but just the date is pushed back 6 months. So we are also planning to keep customer rates the same during that 6-month period, question mark, question mark, question mark. So no non-bypassable charge for securitization added to their bills and no immediate rate credit on their bills from the San Juan savings. We would, however, look to incur all the San Juan savings into a regulatory asset that would later be provided back to customers, question marks. Seems in our San Juan testimony, we committed to a few things on this issue, so we're still in alignment with that testimony. My question to you is, was there ever a response to Mr. Falgren that you're aware of by anybody?
I wasn't copied on these emails, so I wouldn't know.
Okay, but I'm not asking you just about the emails. My question is, was there ever a response by anybody to these questions that you're aware of? Did you ever hear anybody respond to him anytime?
Once again, I wasn't even aware of these emails until I saw it in Discovery, so I'm not sure what you're asking me.
Did anybody else ever raise these questions? Did anybody ever ask these questions in your presence?
No.
Through email, any communications? Did anyone ever bring up questions like this or discuss what about the immediate credit on the bills? That maybe this isn't, is this consistent with what we promised in our testimony or whatever, in alignment with that testimony? Did anybody but Tom Falgren ever express any doubt about Pnm's decision to delay bond issuance?
Objection compound.
Can you answer that?
Go ahead, Mr. Monroy.
Thank you. So a couple of things. I don't agree with your characterization of Mr. Falgren's email. It appears that the first part of this email is Ray sending a draft comms plan to both Ron and Tom on Tuesday, January 11th, asking for their review and edits. So first, I think Tom is responding to whatever messaging is included in the draft comms plan. I'm not sure he's questioning what's in the plan. Rather, he's just making comments as he was asked to do on there. And so there's no, I guess I think you're inferring something that I'm not seeing from this email.
Yeah, I'm not asking you.
In reading through it, the one thing I would point out, he makes a comment, we would, however, look to incur all the San Juan savings into a regulatory asset that would later be provided back to customers. I mean, to me, that shows, in my opinion, a lack of his understanding. A savings wouldn't accrue into a regulatory asset. I mean, a savings generally would be a regulatory liability. And no, that was never part of the plan. That was never in any testimony, nor part of any internal discussions. And so I think he was providing comments and impressions based on whatever was in the draft comms plan.
My question was a little different, though. I wasn't limiting my question to what is said in this email. My question to you is, did anybody, to your knowledge, ever express reservations or doubts about whether Pnm's further new plan to delay issuance of bonds to coincide with a rate case? Did anyone ever express any doubts about that?
I guess I just don't agree with your characterization that it was a new plan.
Okay.
Things
What do you want to
changed.
call?
There's no plan. Things changed. We went through the COVID-19 pandemic. We went through the merger agreement. Merger commitments were made regarding the timing of Pnm's rate cases. We continually are updating and evaluating our plans. And so there wasn't a distinct moment, I guess. And no, during that time, it was clear internally that the bonds and the timing of the next rate case would stay in sync. And that's been a constant assumption that we've provided to our board of directors and our long-range plan assumptions and in all of our financial projections.
So that's what you provided to all the Pnm people. All the Pnm people have it in their heads that bonds will be issued to coincide with the conclusion of a rate case. I think that's what you just told me, right?
So financial plans, long-range plans, they are not provided to all P&M personnel. There are a lot of forward-looking statements that would that are privileged information, maybe not privileged, that's probably not the right word, but forward-looking earnings projections. So that information is not provided, it's not disseminated company-wide because that has such sensitive information provided in there.
Could you please go to page 16 of that 21-page document I had you open? CCAE Exhibit 15, the one that Rick has 3 of?
No, I don't. I have 2, and it appears that CCA 14 was mislabeled as CCA 15, if you look at the exhibit label.
Do you have that 21-page document, Mr. Monroy?
Yes, that starts with securitization messaging, excuse me.
That's right. Okay. And for the record, this is page 17 of the 21-page response to P&M Exhibit CCAE Interrogatory 14-6, which is marked CCA Exhibit 15 for identification. So this is securitization messaging, and the top line says brainstorming, potential outcomes, credibility. P&M indicated in SJGS case, we would issue bonds close to the timing of closure of SJGS and made its abandonment and financing cases early to achieve this date. Period, comma, at the same time we changed rates to reflect changes in our cost to serve customers. Now P&M indicates that can be delayed. So there really was no need to file financing case so quickly ahead of SJ abandonment. What did P&M indicate can be delayed? Does that refer to the bond issuance?
I'm not sure what that sentence is referring to specifically that can be delayed. I mean, I guess you could read it that both the issuance of the bonds and the rate case will be delayed.
Could you go down to, all right, let's keep reading. Explanation. Early filing enabled some flexibility in the path and timing for achieving our emissions-free objectives. Early filing also allowed other stakeholders to better plan for the transition and allowed for economic aid to be paid in advance of the closure of the plant to timely provide monies ahead of the closure to those impacted most. Absent the appeal to the Supreme Court, these monies would have been available last year. P&M has developed a plan that keeps the power running and delays a rate increase for the next year. By using the funds from its retired coal plant, P&M can successfully mitigate its expenses on the grid. So that's P&M's explanation. And the next is the risk. And the risk. This runs the risk of looking like a corporate shell game, eroding our credibility for future proposals and planning. This could make next year's rate case a taller hurdle. Impression of the company could have long-term implications for their reputation, brand, and trustworthiness, not only for customers, but also for regulations. And the last line, why don't you read that one for me? P&M is
trying to avoid paying the bonds and saving to customers. This may be viewed as a corporation that breaking promises that we made.
Is this not an acknowledgement?
No.
It's not? Okay.
No. This is an exercise through our communications plan.
Okay.
Not an acknowledgement of anything.
Okay. So let me just go back to the interrogatory itself, and I think that is exhibit. I'm having a problem with I'm sorry, Mr. Hearing Examiner, I'm gonna have to take a second. I've got my computer plugged in and it's not charging. And I'm gonna run out of batteries here in a second. And I don't know why it's doing this.
And Ms. Zer, while you're doing that, we're at about 5 minutes.
Okay, thank you. Well, hopefully my charge will last 5 more minutes. Why was P&M so concerned about delaying the issuance of the bonds? And
I never said we were concerned about delaying issuance of the bonds.
does P&M, I'm going to withdraw that question. Let me go back to the interrogatory. I'm going to go back to Zoom and look at Exhibit 12. Okay, and so 14.6, what we were just looking at was P&M's response, the attachment to 14.6. Here's the question. What communications preceded the decision to send the survey out to customers? For each communication, provide the date, communicating party, and all recipients for the communication. So I think you told me that this was just your communications plan, but these communications we just talked about in 14.6, those were actually just P&M's own discussions amongst itself prior to the survey, right?
I do not know. Like I said, I'm not really aware of the survey other than when I read through it in Discovery.
But you're aware of what I just read you, which said that that came before the survey. In other words, those risks we just talked about, this was P&M's internal conversations to each other before you sent out a survey. You were telling me this is just about communications, but this is what you all were talking about, right? In the context of what we need to, find out from our customers.
No, I
customers about.
I guess I don't agree with that characterization. I know there was a comms plan. As part of that communications plan, I knew there was that kind of discussions where they looked at how other parties, P&M fully recognizes that other stakeholders often take different positions than P&M has. And I knew that that was an exercise that the communications group was running. I don't doubt, or I don't know the timing of when that plan was done versus the survey, just because I'm not really aware of the survey. I'm not trying to dispute that it was done before the survey. I'm just saying that exercise, maybe it had to do with the survey, maybe it didn't. I don't know.
Mr. Hearing Examiner, if I haven't already moved exhibits 8 and 9, which I referred to earlier, I'd like to move those now.
May I have a moment? So I can.
Yeah, you mentioned quite a few after that, but we're going back to just 8 and 9.
That's correct. Those were the 2 interrogatories from 2019.
I'm waiting for Mr. Alvidrez to review them.
No objection to exhibit 9. Exhibit 8 refers to refers to testimony, which is in the record already. So no exhibit to 8 either.
Okay. CCAE exhibits SC-8 and SC-9, assuming they are properly labeled and reloaded to Dropbox or re-uploaded to Dropbox with the proper appellation as SC-8 and SC-9 are admitted.
Okay. I'd also like to admit CCA 15.
Let's look at that one, Mr. Alvidrez.
And no objection to CCA 15.
All right, thank you, Your Honor. I'm going to stop with 1 second left. Almost had it.
And with regard to CCA 15, CCAE exhibit SC-15, emphasize SC-15 is admitted subject to being re-uploaded accurately labeled as CCAE exhibit SC-15.
And on that, I think there needs to be a correction made to the other CCA 15, which I think was uploaded as CCA exhibit 14, but it is mislabeled as 15, at least in my file.
Yep, you're right. I will fix that too. Thank you.
And one other matter. Mr. Monroy was asked some questions about CCA 11, which is a rule. Specifically, it's Rule 1.2.2.11 relating to pleadings. While I objected, and I think the question was withdrawn, it was represented to all of us that this was the complete version of the rule. However, after looking at the rule itself, it omits subsection B relating to supporting exhibits, which I think was material to the discussion that was going on. Subsection C regarding form and size, subsection D regarding interrogatories, subsection E regarding title and docket number, and subsection F regarding construction. So that is not a complete version of the rule as represented.
I was referring to the part we were discussing, but I apologize for that. We didn't admit it and he didn't answer my question, but I do plan on asking for about that again, and I will get the full version.
But you don't really need to have that admitted as an exhibit though, do you?
Right. But I do need to have the right copy for the witness, and I will get that.
Yes, but I wouldn't expect, even if you have the right copy, that you need to have that admitted. You could just have it for discussion purposes, right? Because it is actually a commission rule.
Right.
Okay. It's fine to have it uploaded. It's proper to have it uploaded for discussion, but I wouldn't necessarily entertain its admission.
Okay. In that case, I uploaded the portion that I thought pertained here, and I'm sorry if I misrepresented the whole thing was there. That was a brain bleep, and I didn't realize that. So I do apologize, Mr. Alvidrez. But for the sake of discussion, Mr. Alvidrez, can we just use that section, or would you prefer that we discuss the whole thing?
We need the whole rule.
Okay, I will do that. Thank you.
Okay, we are too close to the lunch break to start the next cross-examination. So what I propose to do is to break now for an hour and then start with Ms. Nanazi's cross-examination of Mr. Monroy at 1 p.m. sharp. Can we do that?
Yes, sir.
All right. With that, then thank you, Ms. Nanazi. With that, we are in recess until 1 p.m. See you all then. Have a good lunch. Thank you.
You know, if you want, you can get more oat creamer too, because this is starting to go bad, and also, it's almost empty.
Ms. Nanasi, this is Henry Monroy. I just want to let you know that you're not on mute.
So you know I've asked for more oat milk.
Yeah, we know all about your creamer.
No worry. It's just like my largest fear that I'm never on mute. So I just wanted to.
Thank you so much. That's the kindest thing you've ever done.
That's like if you have spinach in your teeth, right? Somebody needs to tell you.
Well, this spinach in your teeth is worse, I think. But
Yeah.
now, of course, I'm already like, is there apple in my teeth?
Yeah, Bob, can you bring me another vial of spirulina, please?
I vote for something stronger. Makes for an interesting record.
Yeah, I'll try not to order margaritas while I'm, not on mute at least.
I'm laughing.
Hey, Mariel. This is Jason.
Hi.
I wasn't able to open your exhibit list. The file extension was a .ps, which my computer didn't know what to do with. I don't know if it's.
Really? Okay, well, I'll send it to you, but did anybody else have that problem?
This is Kelly. I can open it.
You can?
Yes.
Okay.
Is it just a regular PDF?
I just opened it on Dropbox. I didn't try to download it.
Oh, Hearing Examiner told us not to do that.
Oh.
You know what? I will send it to you right now.
Yeah, I downloaded it and now it's just a regular PDF.
Oh, it's funny. Okay.
But I'll send it to you.
Okay.
I don't even know what .ps is.
.ps Photoshop.
That's crazy.
Good afternoon, all.
Hear me okay? Can you hear me?
Afternoon, sir.
Yes, ma'am.
Sure can.
Oh, I did not forget your request. I just can't generate it once I'm in the file. So I will have it for you tomorrow.
That's fine. I'm sorry. I should have remembered to request it, but that'll be perfectly fine. And thank you for providing it tomorrow. We're back this afternoon for the continued cross-examination of Mr. Henry Monroy. It's Ms. Nanazi's turn. Ms. Nanazi?
Mr. Hearing Examiner, before we start.
Yes, sir.
in looking at the NEE exhibit list, I had understood, and I think other parties must have as well, that we were to designate which exhibits were going to be used with which witnesses. And there isn't any indication about which NEE exhibits will be used with which witnesses. Is that something we could get some clarification on?
Mrs. Nazi?
That is true. I forgot to do that. So I could tell you right now, in terms of Mr. Monroy, and I apologize, first of all. And second of all, I could refile my new energy economy exhibit list and have another column and put in there a list of who I'd use for what.
But for now, can you identify for Mr. Monroy for P&M and for the parties, the exhibits that you're about to, so that we can just move on?
Yes. The main one that I want to ask him about is NEES 3, though I did want to ask him a couple of questions, very few, on to follow up on the CCAE questions. And really, I think the rest are on Mr. Monroy's testimony himself.
Okay, so could you please just identify, it's NEE-SC-
3.
3?
Yeah. Which are mostly.
Which is P&M's second corrected response to NEE-14?
Yes, sir.
Okay, so it's that one, and then Mr. Monroy's direct testimony and perhaps his rebuttal testimony?
Correct. Which is a P&M exhibit.
Right, right.
And
I'm
sorry.
Just so we're all on the same page, I'm sorry.
Yeah, and
Go ahead.
I for any future witnesses, I'll be happy. I think most of the rest are for Mr. Don Terry. And I do have some questions on CCAE exhibits.
So after today, please re-upload your list of exhibits with that column that identifies the witness to whom the exhibit corresponds. Thank you. And you may begin your cross-examination of Mr. Monroy when you're ready, unless there's something else that the parties wish to address right now. I do have one thing while you're getting ready, and that is, it doesn't relate to any of the parties here, but I had a request from one party from the underlying case, specifically from the community groups. Counsel Ali Beasley requested excusal from the evidentiary hearings pursuant to an email I received this morning, and the community group's request for excusal is granted. Okay, Mrs. Nazi, are you ready?
Yes, I am, sir.
Okay, please proceed.
Mr. Monroy, I'm going to ask you if you wouldn't mind going back to the exhibit that Ms. Zur was asking you about, and that is CCAE 15. Tell me when you're there, sir.
I'm there.
Now, first I wanted to just ask you, I think your testimony was that the first time you saw this document was in preparation for your testimony, that you were reviewing discovery?
I think that was referring to this email.
Okay. But isn't your name and these documents attached to the first pages? Or no, actually, it's the third page of this document.
That's a different email.
Right, but it is.
I was referring to the first 2 pages of the email.
Okay, and this one is on the third page. You're included on this email, and there are attachments that it says draft comms plan, semicolon, redraft comms plan. So maybe that was just a repeat. So is it your testimony that you had never seen these documents until today?
No, that
Or
wasn't.
just
I know if you're referring to the survey is what I said I had not seen. The comms plan is not the same thing as the survey.
Okay, so specifically around the comms plan, you had seen this comms plan before your preparation for today's testimony, is that right?
That is correct.
Okay, could you please turn to page 7 of 21 of this document?
Yes, I'm there.
So at the top of this page, it says bond delaying messaging. That's all in caps. And then it says dash positive dash illustrate how much we've spent since the last rates went into effect. A couple billion per TIM dash we've spent XYZ. And here's NEE saying ... taking 90M from customers. Compare company investments on behalf of customers to delayed costs and benefits of bonds. Is that right?
That is what it says.
And so could you tell me about what that means?
So I wasn't the author of this document. This appears to be a draft of the final comms plan, as you can tell by things that are redlined. So I guess that's what I can tell you about it.
Well, can you tell me about what I just read? What does that mean?
Let's see. Positives illustrate how much we have spent since the last rates went into effect. A couple billion per TIM. We've spent XYZ, and here's NEE saying, I'm not sure. I mean, I guess it speaks for itself. I think what they were trying to talk about was the concept of what we have spent the money on and what we've invested in since our last rate case. And that the cost of those, the savings or the cost reductions from San Juan have helped to mitigate those investments. So the cost increases to customers are mitigated.
What is it? Why is there any reference to new energy economy?
I don't know. Like I said, I didn't author this document.
Who authored it?
Ray Sandoval.
So was there discussion about why is there an emphasis on new energy economy right there?
Not to my knowledge.
So could you go please to, believe it is. So it's true that what not only new energy economy, but the other interveners are saying that basically our position is that P&M is taking around $90 million from customers, and that your retort to that is that you've been spending so much money for company investments. Is that correct?
No, that's not how I would characterize it.
How would you characterize it?
So I think what the show cause motion requested was for P&M to implement an interim rate credit upon the abandonment of San Juan. And our position is that's not what was ordered in the financing order or not included what's in the ETA.
But I didn't ask you about that. I asked you about in reference to this document, this messaging that P&M wanted, that it's focused on
Pnm's response that the company is making a lot of investments. Is that right?
So the investments referenced there are the same investments that I referenced in my direct testimony in this case. Those investments were brought up to rebut a couple of positions of claims that the rates that we charge customers would be unjust and unreasonable after the abandonment of San Juan.
Could you go to page 12 of this document, 12 of 21?
Well, I'm there.
Okay, so the last bullet is under a heading, step 4, continue to maintain control of the message, semicolon, mitigate risk. And then the fourth line down, fourth bullet down, it says responding positively to any media inquiries and redline knee and retake our democracy newsletters / press release. Do you see that?
I do.
What does that mean? What does redline mean, first of all?
I have no clue. I wasn't involved in this page of this document.
And so when you were sent this, and did you read it?
I would not have read this part that related to messaging. I'm not involved in this part. So I was reading the other parts for more factual information. I'm not sure. Like I said, no, I didn't read this page.
Of all the pages, you didn't read this one.
I can't say all the pages if there's not more that I haven't read. Flipping to the next page, I didn't look at that one either. But
you were, you acknowledged that you were, that this document was, you see it on the email to you, correct?
Yes.
Okay. Let me ask you something. Who does Ms. Eden answer to?
She reports now to Pat Vincent Colon.
And
to clarify that, that's based on a new change that occurred this week. Prior to that, she reported to Don Terry.
And Don Terry is the CFO of P&M, is that correct?
So he was the CFO. I believe he got a new job title recently.
When was that?
Thursday?
After the deposition?
Yes, I believe it was on Thursday.
And what's his new title?
Subject to check, I believe it's President and Chief Operating Officer.
Who's the CFO?
Lisa Eden is now.
P&M San Juan abandonment and securitized financing application and testimony earlier in this case resulted in a PRC order that approved P&M's financing order to recover all of its energy transition costs through the issuance of energy transition bonds. Is that correct?
That sounds correct.
In P&M's application and testimony, including your own direct testimony, P&M testified that its consolidated abandonment and securitized financing and replacement power would result in customer savings. Is that correct?
Yes, that's correct.
When P&M responded to New Energy Economy's appeal to the New Mexico Supreme Court defending ETA securitization, P&M also promised customer savings resulting from its consolidated abandonment and securitized financing and replacement power application. Is that correct?
I don't know. I wasn't involved in the appeal.
Did you not see any of the documents that were filed by P&M saying that the application and specifically the securitized financing would result in customer savings?
I just said I wasn't involved in the appeal. But I imagine it would have summarized what was the evidence in the case. And so I have no reason to doubt that's not what was in there.
Thank you. Is there any place in the recommended decision or the financing order that authorized P&M to alter the date of bond issuance depending on when P&M received a rate increase pursuant to its next general rate case filing?
No, but there's nothing in the financing order that set a date specific for when the bonds need to be issued.
When P&M was working on getting the legislature to pass the ETA, did P&M ever disclose that it intended to time bond issuances to coincide with rate cases that would take place when P&M wanted them to, rather than the date of abandonment?
I don't know.
Your testimony acknowledges that when P&M was before the PRC in the past and estimated the date of issuance of the bonds, P&M said they'd coincide with the date of abandonment. No? Is that right?
I mean, my testimony, I guess, says what it says. I mean, I think my testimony was clear in that we estimated that we would issue the bonds at the time of abandonment, and then we estimated that we'd also file a general rate case to coincide at around that same time.
There was nothing in the recommended decision or the financing order that disclosed or even suggested or implied that the date of issuance of the bonds would be tied to commitments P&M and Avangrid would make in the merger case, was there?
No, I don't think the merger was even known at that time.
You know that during the pandemic, P&M filed a petition for approval of a rate adjustment mechanism to remove regulatory disincentives and original rider number 52, otherwise known as its decoupling filing, in May of 2020.
I know P&M made a filing for requesting of decoupling, yes.
And P&M voluntarily withdrew that application, correct?
I believe that they requested for a declaratory order on the rule. If that means that they voluntarily withdrew it, then I wasn't involved in that case, but my understanding is they did forego the application, asked for a declaratory order on the decoupling rule.
And so P&M never received any revenues as a result of its decoupling filing. Is that correct?
That is correct.
In what filing or order does P&M's unilateral decision to delay the bond issuance from July 2022 appear?
I'm not aware of any required filing to be made.
So is your answer that there is no filing or order that that you're aware of, or that the company is aware of, that reflects its unilateral decision to delay the bond issuance from July 2022?
Yes, like I said, I do not believe there's any requirements that I'm aware of to notify the commission. And that, yes, that's my answer.
Sir, could you please turn to SC3.
All right, I'm there.
But I'm not, so that's funny. Okay. Okay, here we go. You provided the answer to First of all, just tell us what this document is, please.
Sure. So NEESC-3 is PNM's second corrected responses to New Energy Economy's 14th set of interrogatories.
Thank you. And you provided the response along with Ms. Kelly Alcantar, which for the court reporter I'll spell as Kelli, last name Alcantar. So along with Ms. Alcantar, you responded to the question 14.1. Is that right?
That is correct.
And if you could go to 14.3, could you please read the first paragraph under the heading objection/response?
Sure. The deal model was the 2020 to 2024 long-range plan, PNMR, presented to the PNMR Board of Directors on February 21st, 2020, that was updated in August of 2020 and shared with Iberdrola/Avangrid during merger negotiations. The deal model financial results were included in the section certain unaudited financial forecasts prepared by the management of PNMR included in the proxy statement filed with the SEC under Schedule 14A on December 18, 2020 and January 5th, 2021 related to the merger transaction.
And you provided that answer. Is that correct, sir?
That is correct.
And could you please go to 14.4? Could you please read again the very first paragraph under objection/response? And also, could you please state if you were the respondent to this question?
Sure. The August model referred to in the email correspondence refers to the long-range plan database that was used to create the September 2021 long-range plan model that was presented to the PNMR Board of Directors on September 20th, 2021. And then I was the respondent or the sponsor of NEE 14-4.
Is Don Terry, up until before last Thursday, was Don Terry your direct supervisor?
Yes, he was.
Could you please keep this open and also open NEESC1, Mr. Fetter's testimony at the same time, please? And once you're there, could you please open SMF4?
Is that in Mr. Fetter's testimony?
Yes, please, sir.
I don't recognize that. Is that an exhibit to his testimony? Is that what?
Yes, it is an exhibit to his testimony.
The long-range plan assumptions.
No, actually, it's a number of emails that, and it's from, the very first one is from you. And for the record, it is, it's attached to Mr. Fetter's testimony, which is NEESC-1, and then it's exhibit in his testimony as SMF-4, and it is PNM exhibit NEE 12-12B, and that was delivered on April 27th, 2022, and there's 18 pages of that document. Do you see that, sir?
Yes, I have found it.
Thank you. Could you go first to page 3 of that document? because this question that I'm going to ask you about refers back to this interrogatory. Tell me when you're there.
I'm on page 3 of 18.
Okay, so if you could go also, as I've asked, if you could look at interrogatory NE 14-5, and it specifically refers to this this email. And would it be okay with you if I ask the questions and then you provide the responses that you did in fact provide as the respondent to this question?
Yes, that's fine.
So the question is, on November 2nd, 2021, Terry asks, and then there's a parentheses, NE 12-12B, page 3. Can someone pull together the numbers from what we would assume if we did the HE rate path compared to deal model dash, need to see the comparisons pretty quickly. So if you also have Mr. Fetter's SMF4, that is referring to that document. Is that correct?
Mr. Hearing Examiner, I apologize. I am looking at the Fetter testimony as filed, as pre-filed, and it had clearly marked exhibits to it. And when I look at what was downloaded as New Energy Economy Exhibit SC-1, those marks seem to be gone. Those labels seem to be gone. So I was having a difficult time. I think many of us may have been having a difficult time because the exhibits appear to have been altered.
Mr. Hearing Examiner, is that what you see as well?
I'm looking at SC-1 and it looks similar to what I had on screen as well, which was what you had pre-filed earlier in the case. I'm not sure what you're referring to, Mr. Albedres. Could you point us to something?
Yes, here's the exhibit. I'll put it up, and it has a clear label on the top. And what I have, at least, was printed off from the website. No longer has exhibit numbers, at least.
Oh, but I see PNM exhibit NEE 12-12B.
It does, but it no longer has the exhibit number SMF4 in this case.
That
looks
I
like
see. I see SMF4, what I downloaded from what was uploaded. What you just held up has that SMF-4, right?
Right. This is from the pre-filed, and what was downloaded. Yeah. What was downloaded does not appear, at least in what I got downloaded, does not appear to have any more exhibit markers to it.
Well, by the way, Mr. Nazi, I paused your cross-examination to address this, but I have SMF-4 from what Mr. Nazi uploaded.
All right. Well, I'm not sure what occurred. Thank you.
That's okay.
I mean, I can show you what.
But Mr. No, but Mr. Nazi, that's. I mean, I literally. Yeah, it's labeled NEE SC-1. I downloaded it. I'll download it again just to see. No, yeah, it's labeled correctly as far as I can tell, as far as that exhibit that we're talking about. So I'm going to
Were there downloads after 5 o'clock on Saturday? No.
No. All right. In any event, let's go ahead and resume the cross. Mr. Nazi, did you have a question on the table?
Yes, thank you, sir. So I was just trying to have both of these documents open at the same time because New Energy Economy 14-5 actually refers to this page so far, and we'll get to more in 1212B, right? You see that, Mr. Monroy?
Yes.
Okay, so then I'm asking you, and if you could answer them like you did in the interrogatory. A, who/what is the HE? Could you please respond?
This is in response to the certification of stipulation in case number 20-00222-UT issued on November 1st, 2021. The HE is the hearing examiner in that case, Ashley C. Schanhauer.
B, what does the HE rate path mean? Could you please state your response?
The HE rate path in this email is referring to the recommendation in the certification of stipulation in case number 20-00222-UT found on page 72 in quotations. If the commission decides to approve the proposed transaction in some form, the hearing examiner recommends that the stay out be extended for at least an additional 6 months to December 1, 2022.
C, is the HE rate path the path according to the financing order?
C is no. Please see Pnm's response to NEE interrogatory 14-5 in parens B.
D, is the HE rate path the path according to the interim rate credit path?
The response was no. Please see Pnm's response to NEE interrogatory 14-5 in parens B.
E, please explain in narrative form what the comparison demonstrated between the HE rate path and the deal model. Could you please read your response?
The comparison is provided in PNM exhibit NEE 12-12B, parens April 27, 2022, close parens, page 1 of 18 in the email from Kelly Alcantar, dated Tuesday, November 2nd, 2021 at 11:55 a.m. The analysis showed a $24.1 million reduction to PNM pre-tax earnings in 2023 compared to the September 2021 long-range plan provided to the PNMR Board of Directors on September 20th, 2021. This analysis further confirms that the delay of PNM's rate case results in customer savings.
And sir, could you please turn to SMF4 now? And when you said in your response to subpart 14-5E, you were referring to page 1 of SMF4. Is that correct?
Oh, I'm sorry. What I have in front of me is the same problem Mr. Alvidre has, but yes, that is correct.
Okay.
4.5 minutes, Mr. Nazi.
Mr. Medeiros, is it possible if I can have 7 minutes from my settlage time? So that would mean I would only have 3 minutes for settlage. Can I add that, please?
So you'll have about 12 minutes left. Yes, done.
Thank you. Now, sir, if you could look at New Energy Economy 14-6 and 14-7. And this was regarding, without reading the whole thing, it's regarding a question that New Energy Economy asks about all correspondence with any members of Iberdrola or Avangrid regarding the rate freeze offered in NMPRC case number 20-00222 UT and how it relates to the deal model and or the August model. Do you see that?
I do see NEE 14-6 and I believe 14-7 refers to the deal model and or the August model. Yes.
Okay, and so P&M's response to both of those, there were some objections, but then P&M's response refers New Energy Economy to the July 29th, 2021 rebuttal testimony of Ronald N. Darnell and P&M's exceptions to the certification of stipulation in case number 20-00222 UT for publicly available information concerning the proposed rate freeze. Is that correct?
That is the answer. As you pointed out, there's an objection that you did not read. That's quite
Right.
lengthy.
And Mr. Hearing Examiner, I want to object to this line of questioning. We also have a supplemental response that was agreed to with Ms. Nanasi, which is not, which supersedes this. So there is a supplemental response that resolved a discovery dispute that was submitted last week, and that's not included. So I object to any suggestion that this is the current state of P&M's response to these interrogatories.
Okay, can I ask a question to follow up with that?
Please do.
Thank you. Is there anything in Mr. Darnell's testimony or P&M's exceptions in the merger case that indicated that it was P&M's decision, once it provided the rate freeze benefit, that it would also move the issuance of the energy transition bonds?
Not that I'm aware of.
And you know, of course, that the merger was rejected by the hearing examiner and the PRC, correct?
Yeah, I believe the certification of stipulation recommended against the stipulation, and the commissioners approved that recommendation.
And therefore, the rate freeze, like all the other commitments that were offered by P&M and Avangrid, are non-binding.
I'm not sure about non-binding. I know that P&M, I believe with Avangrid or the joint applicants, have appealed that decision up to the Supreme Court.
Is it your understanding that the merger commitments are non-binding on any party at this point?
I can't answer that. I don't know if they're non-binding or not.
Okay. And Mr. Monroy, you were the respondent to interrogatory New Energy Economy 14-8, 14-9, and 14-10, correct?
Yes, I was.
If we look through everything that P&M filed in this case and everything it said to the legislature in support of the ETA, the date of issuance of the bonds was tied to the date of abandonment, wasn't it?
I assume when you're talking about this case, you're talking about the case back in 2019 in this docket. And yes, P&M included its estimate of when the bonds would be issued, and they had estimated those bonds to be issued near the time of abandonment.
The projected net book value for San Juan Unit 1 is $90.8 million after the planned abandonment date of June 30th, 2022. And San Juan Unit 4 is $185.7 million after the plant date of September 30th, 2022. Is that correct?
I apologize. I'm now in my direct testimony. And if you said 90.8 million at June 30th, 2022 for San Juan Unit 1, then I agree. As far as San Juan Unit 4 and remaining common equipment and plant, did you ask September 30th?
Yes, sir.
as September 30th is projected to be $185.7 million.
And you just, I see that you're looking at your testimony and that was on page 38, correct?
Yes, page 38 and page 39.
Those net book value figures would remain the exact same in December 2023 or June 2024 or any other date. Is that also correct?
That is correct. As I explained in my testimony, under generally accepted accounting principles, once the plant is no longer used and useful, the plant will stop being depreciated, will be removed from utility plant and service, and will be recorded as a regulatory asset as authorized by the financing order.
If Pnm's current plan were accepted as reasonable and energy transition bonds weren't issued until January 2024, ratepayers would be still paying undepreciated assets on San Juan units 1 and 4 and a full return on those undepreciated assets, but there would be no actual depreciation of those assets. Is that correct?
No, and both my direct testimony and my rebuttal testimony addresses that.
Can you explain why that is not correct?
Sure. So the rates that we're collecting today, sorry.
No, I'm sorry. I didn't know you were looking. I just wanted to try and give a silent warning of 5 minutes. So apologies.
I apologize. I thought you were telling me to
Thank you
hold
for-
that. I apologize for that, Mr. Hearing Examiner.
No, thank you for being so alert of a witness. My
Okay.
apologies.
I'm so sorry. What was the question? I lost my train of thought.
I asked you if Pnm's current plan were accepted as reasonable and energy transition bonds weren't issued until January 2024, ratepayers would still be paying undepreciated assets on San Juan units 1 and 4 and a full return on those undepreciated assets, but there would be no actual depreciation of those assets. And you said that that was not correct. And I asked you to explain.
Okay, yes, thank you. Thank you for that. I apologize for that lack of train of thought. So essentially why that's not correct is the rates that are being charged today are based on a cost of service that was filed that reflected a 2018 test period. However, once those rates are set, they are not reconciled back to any individual cost component that was included that was used to set the rates. And so that is why that your question is incorrect. I mean, in a summary, in a nutshell.
But basically, if the unit was continuing to go not to be abandoned, then and the financing order would be pegged to the abandonment date in the future. Is that right? Like if you would just apply now under the ETA, the financing order would be pegged to the abandonment date, right?
So to clarify, the estimate of energy transition costs is defined within the ETA as to be the value of the undepreciated investment at the time of abandonment.
And so when you made that estimate that ended up being the $360.1 million, you pegged it to the abandonment date of June 30th, correct?
That is correct. The $283 million was the estimated undepreciated investment at June 30th, 2022.
And if Pnm's plan were to be approved by the commission, that you could still continue to have in rates the amount that Pnm had previously determined was the non-fuel revenue requirement for San Juan, that would have included the undepreciated investments plus a return, and it would continue. Is that right?
So as I stated, well, a couple of things. I'm not sure we're asking the commission to approve any plan. We are responding to a show cause motion of why there is no need to grant the show cause. So there's no plan P&M is asking the commission to approve. And then, as I stated earlier, the premise of your question is incorrect in that rates aren't designed to collect any one specific underlying cost of service item. And in my rebuttal testimony, I give an example of the offsetting issuances of something included in the cost of service that has since expired, but there's no reconciliation or true up related to those.
Yes, Mr. Hearing-Examiner, I'm almost done, but I think I need to take 5 minutes from Ms. Sanchez. I really apologize, but I think that it's important that I finish this line of questioning.
Okay, five more minutes granted.
Thank you. Okay, I understand that there's no specific amount that is calculated forward, but when you did that cost of service, you did have a specific amount that was tied to San Juan units 1 and 4, correct? In 2016?
Rates are set based on a test period provided for which the commission can then determine what just and reasonable rates should be based on.
And if you were not going to abandon San Juan in July 2022 or September 2022, and later down the road, let's say in January 2024, there was a new financing order and you would peg it to the date of abandonment, right? And that date would have been what the net book value of abandonment on that date would have been, right?
Yes, I already agreed. Energy transition costs defines the undepreciated investment to be the value at the date of abandonment.
And even though the cost of service is not specified going forward when you're charging rates, the net book value would have changed if it would have been determined at June 30th, 2022 or January 1st, 2024, right? That net book value would have changed if there was no abandonment, right?
Well, I mean, if there was no abandonment, I'm not sure we would have filed for a financing order.
I know, but I'm asking you this: if instead of abandoning at June 30th and September 1st or October 1st, you were abandoning it in January 2024, the net book value wouldn't be $283 million, would it? It would be whatever the net book value would have been in January 1st, 2024, right?
Yes, that is correct. Under generally accepted accounting principles, if the plan is still used and useful, it will continue to be depreciated.
So between July 1st, 2022, and let's say January 1st, 2024, while P&M ratepayers are still paying for San Juan costs that are included in rate base, they are not going to be credited any reduction of depreciation for those undepreciated investments. Is that correct?
It's the premise in your question is what's incorrect, and that you continue to say that the rates being charged today are specifically reconciled back to any one underlying cost of service item included in the test period cost of service. So no, the rates are charged of what it costs to provide electric service to customers. Those rates are deemed just and reasonable until such time that the commission or the utility request for those rates to be reviewed and reset to determine what a new just and reasonable rate should be.
So but what I'm asking you is, even though P&M ratepayers will be continuing to pay under P&M's current plan, the cost of undepreciated investments and a return on it for San Juan units 1 and 4, those will not be reduced it will not reduce the amount of undepreciated investments at all. Is that correct?
I mean, Ms. Nanasi, you've said that a couple of times, and I continue to disagree with your premise that the rates are specifically collecting San Juan and should be reconciled back, as you're suggesting. So no, I don't think that is correct.
Is it true that HEM4 shows that the 58,668,000 is the estimated non-fuel revenue requirement associated with 6 months of operation of San Juan Unit 1 and 9 months of operation for San Juan Unit 4 and Common Plant in 2022?
Yes, that sounds correct.
I have 3 more questions, Mr. Hearing Examiner. I would like to take another 2 or 3 minutes off of Ms. Sanchez.
Done.
Thank you, sir. P&M has not quantified or calculated the actual non-fuel revenue requirement for San Juan Generating Station for years 2018, 2019, 2020, or 2021, correct?
That is correct.
And when New Energy Economy asked P&M to make this calculation, the company declined. Is that correct?
I think you're referring to a discovery response that was objected to.
By you?
Yes.
And you said that you would not perform those calculations. Is that correct?
I don't have the exact language of what the objection was and what it said in front
But
of me.
that was in essence what was meant by P&M, that you wouldn't perform those calculations.
Yes, I mean, I think there were calculations that we did not have readily available. I think we cited to the amount of time it would take to prepare those calculations. The 2022 calculation was only available as we were ordered to provide it in the procedural order for this hearing or for this phase of the case, excuse me.
Based on 2022 alone, approximately how much profit would P&M be making between what it was granted authority to collect for San Juan in case 16276 and P&M's actual costs for San Juan?
I'm not sure I can answer that question. And once again, I will continue to point out the fallacy in the calculations you're asking, or that what that question assumes, because rates do not reconcile back to the original underlying rate base that was included in a cost of service to set rates. That's fundamentally not how an earned return calculation is done. And to point the fallacy of that argument out is plant always depreciates. And so under that line of thinking, the utility would automatically begin over earning in the next year as the plant continued to depreciate, but no rates are changed. And so that's why what you're proposing is just not a valid calculation and runs contrary to general rate making principles.
And yet the hearing examiners in this case asked you just for that exact information, did they not?
The hearing examiners asked for what was the 2022 revenue requirement related to San Juan Unit 1 and San Juan Unit 4. And I believe we added Common Plant, but I believe that was their exact request.
Thank you so much, Mr. Monroy. Thank you, Mr. Hearing Examiner Medeiros, for indulging me and giving me some extra time and removing the time from the other witnesses. And I would move New Energy Economy SC-3 into evidence.
Any objection to the admission of NEE SC-3?
Yes, and I want a little clarification. Is the whole document being moved in? That is all the questions and all the discovery requests and responses, or are you just focusing on certain ones?
Just these questions that are NEE SC-3, just what you have before you.
So all of them that are contained in this.
That's correct.
I do have an objection, and specifically to the discovery requests relating to any interrogatory 14.6 and any interrogatory 14.7, as those are not, reflective of the company's final answers on those two questions. So if those would be struck, I don't have a problem with the rest, but those two I think are not accurate.
Mr. Nazi, the supplemental response is what is of concern apparently to Mr. Alvidrez. If we struck pages 9 and 10 from the exhibit, and would that work for you?
It would, except for I wouldn't want to strike all of 10 because there is 14.8 on there as well, but I could black out those two questions, but if Your Honor would allow me to keep, I mean, that wouldn't strike the questions that I asked Mr. Monroy on them, right? Which, okay.
No.
Sure, I'm happy to black those ones out if you want.
So to be clear, it would just be all of page 9 and then the part of page 10 that addresses NEE 14-7. Below that, NEE 14-8 would remain.
Yes,
Mr.
sir.
Alvidrez, does that work for Pnm?
Yes, that does.
Okay, with that revision to NEE SC-3, which Ms. Nanazi will perform hopefully by the end of the day or tomorrow. Just make sure that that is excised from NEE SC-3. And with that, NEE SC-3 is admitted.
Thank you, sir.
And
thank you,
Mr. Medeiros. One final clarification so we can keep track with the time change that Ms. Nanasi did. How much time does NEE have for Ms. Sanchez left? Is it?
I believe it's 22 minutes. Let me check to make sure. It was originally 30. I have 3 minutes left with Settlage, 22 with Sanchez, and 15 with Atkins, and that still has a balance of 145 minutes. So it's 22.
Thank you for that clarification.
Sure, of course. All right. Up next is NM area. Ms. Gould, I believe you have 90 minutes scheduled with Mr. Monroy.
That's correct. Hopefully I can go quicker.
Okay. We may have to break if you use the full 9. Probably have to break in about. Well, it's at around 3. So it's going to be 2 o'clock now. If you go more than 60 minutes, we'll break at 3 for the afternoon break.
Okay.
So I'll start you now at 90.
Okay, great. Thank you.
You're welcome.
Good afternoon, Mr. Monroy. How are you?
Good. How are you, Ms. Gould?
Doing well. My name is Kelly Gould. I represent New Mexico Affordable Reliable Energy Alliance, NM area in this case. There's been a lot of ground covered, so I might skip through some things a little bit quicker than I had expected to. I believe when you're talking with Ms. Zur, you agreed that section 62-18, well, the ETA requires that there is an estimate. You have to, in order to obtain a financing order, you must provide an estimate timing of issuance of the bond. Is that your understanding?
That sounds correct. Yes.
And you agree that the financing order controls this case. Is that correct?
Yes, the financing order is approved by the commission.
And when I say financing order, I'm referring to kind of the combination of documents, the recommended decision written by the hearing examiners in this case, and then the order approving the recommended decision in full. Is that your understanding also when I say
Yes.
financing order?
I apologize for cutting off. Yes, that's the same. language that I agree to that.
Okay. And is your testimony that the issuance of the bonds is tied to a rate case? That's Pnm's position in this case, correct?
I think our position is that the financing order did not require Pnm to issue the bonds at a date certain. And then Pnm intends to issue the bonds to coincide with the effective rates of Pnm's next rate case. So yes, I guess that's correct.
Is there language in the financing order that ties the issuance of the bonds to Pnm filing a rate case?
Is there language that ties the issuance of the bonds to the rate case? No, like I said, I think the language in the financing order just references Pnm's estimate of when they will issue the bonds.
Can you do you have the financing order?
I do.
Now, when do you say that, do you mean the recommended decision?
I do mean the recommended decision, Your Honor. Thank you. I thought I was clear with Mr. Monroy that I was using the term financing order to refer to the recommended decision.
Yeah, primarily, but we also, as you noted, have the final order
Right.
on it. So I just wanted to
Yeah,
focus,
let me
just to
be clear.
focus this on the RD.
Sure, yeah, if you could please get the recommended decision on Pnm's request for issuance of a financing order and turn to page 20.
Yes, I'm there.
Get my paper. Okay, so here it says Roman numeral 3, issues and recommendations. A, summary of recommendations, is that correct?
Yes.
The second paragraph I'm going to read from, it says the recommended decision, if approved by the commission, would address 5 main issues. First, it would allow Pnm to include in bonds, parentheses, securitization, to be issued by a Pnm affiliate, parentheses, a special purpose entity, the 360.1 million Pnm estimates as the cost to abandon its interest in the remaining San Juan units 1 and 4. This would include the full 283 million estimate of undepreciated investment in the units. The bonds would be issued shortly after the abandonment of Pnm's interest in the units on July 1st, 2022. Do you see that?
Yes, I see that.
Okay, so here, this is the summary of recommendations that the hearing examiners gave to the commission, which the commission adopted. And here it explicitly ties the issuance of the bonds to the date of abandonment of the units. And they say they have 5 main issues. That was the first. The second would authorize Pnm to collect energy transition charges to pay the debt service on the bonds over a 25-year period. Correct?
Yes, that's what that sentence says.
The third paragraph starts, the third main issue, the decision, it says, the decision provides that Pnm will immediately reduce its base rates to limit all of the costs of San Juan units 1 and 4 at the time it starts charging the ETCs. Correct?
That is what it says.
The fourth main issue that the summary addresses, it says, fourth, as required by the ETA, the decision would establish a process to adjust Pnm's base rates in the future to reconcile any differences between the estimated costs recovered in the bonds and Pnm's actual costs. Is that correct?
Yes, that's the first. Yes.
And then fifth, the main issue discussed is fifth, included in the costs to be included in the bonds are 20 million in severance and job training costs for Pnm and coal mine employees, and 19.8 million in payments to state administered energy transition funds for Indian Affairs, economic development, and displaced workers. Is that correct?
You've read that correctly.
Okay. Nowhere in this hearing, the hearing examiner's summary here on pages 20 and 21, do the hearing examiners tie the issuance of the bonds to the rate case, correct?
But I don't think that, I didn't read where,
Could you answer my question? Is that correct?
excuse me, no, but what I would say is I don't see where it ties the issuance of the bonds to the abandonment either.
Can you please go to page 21 at the top of the page? It says the bonds will be issued shortly after the abandonment of Pnm's interest in the units of July 1st, 2022. Do you see that?
I do see that.
That language to you does not tie the issuance of the bonds to the date of abandonment?
No, it provides a summary of the recommendation of that was Pnm's estimate of when the bonds would be issued.
Yes, and this is the recommendation of the hearing examiners that the commission approved, correct?
We've clarified this is the issues and recommendations, paragraph A, summary of recommendations of the recommended decision on the issuance of a financing order.
And your reading of this is that it does not tie the date of the issuance of the bonds to the date of abandonment?
That's correct.
You read this sentence, the bonds will be issued shortly after the abandonment of Pnm's interest in the units on July 1st, 2022 to not tie the date of the issuance of the bonds to the abandonment?
I don't read that as ordering Pnm to issue the bonds at the date of the abandonment. No, I do not. Like I said, this is a summary of the information that was provided in that case.
Okay, and then I don't think you answered my previous question. In the summary, does it tie the issuance of the bonds to Pnm's rate case?
No, it does not. And like I said, there's nothing in the financing order that orders when those bonds are to be issued.
On page 13 of the recommended decision on financing order, if you could please turn there.
Yes, I'm there.
It says the ETA provides for rate, I'm on the third paragraph, 3 sentences down. It states the ETA also provides for rate making mechanisms designed, 1, to eliminate the cost of the abandoned facilities at the time the ETC rates are first collected, parentheses, upon the abandonment of the units.
Yes, I read that.
Okay. And then if you could please turn to page 27 of the recommended decision on financing order.
I'm there.
Under section C, overview of estimated and final cost recoveries. It says the ETA facilitates and ensures Pnm's recovery of the costs to abandon its interest in the remaining San Juan facilities. It provides for the issuance of transition bonds to enable Pnm to recover the estimated costs, energy transition costs, of abandoning units 1 and 4 shortly after the abandonment on June 30th, 2022. You see that?
I do.
And that language does not tie the issuance of the bonds to the date of abandonment?
And that does not tie it. I'm sorry. Can you say that one more
That
time?
language does not tie the issuance of the bonds to the date of abandonment?
No, it says it provides for the issuance of the bonds. It doesn't say it requires the bonds are issued at abandonment.
It provides for the issuance of the bonds to enable Pnm to recover the estimated costs, parentheses, energy transition costs of abandoning units 1 and 4 shortly after the abandonment on June 30th, 2022. Those are not linked events in your reading of this?
I didn't say they weren't linked. I said it provides. It doesn't say it orders it to be issued at abandonment.
Well, this is a recommended decision. When the commission did their order, then they ordered what the recommended decision says. Is that not correct?
It is, and I believe if you go to the ordering paragraphs in the back of the financing order in the RD, those are the ordering paragraphs under which it was approved.
When was the first time that you heard that PNM was planning to delay the issuance of the energy transition bonds until after the end of its next rate case in late 2023 or early 2024?
In late 2023.
I'm
So
asking you, when was the first time that you heard that PNM was
Yeah.
planning to delay the issuance of the energy transition bonds?
well, that's a different question. And so I don't know if I heard anything.
When was the last, when were you? first
Could I
made
answer
aware?
the question that you asked, that you did ask me?
I'd like to clarify my question if I may.
Yes, ma'am. Go ahead.
When was the first time that you were made aware that PNM was planning to delay the issuance of the energy transition bonds?
It would have been when I became aware that PNM was going to delay its rate case that would have reflected the abandonment of San Juan.
So when would that have been?
So I knew we had delayed the first case, but that back in 2020 due to COVID. We still plan to be able to file a rate case for rates going into effect in July of 22. After that, though, when the merger was announced, when the merger agreement with Abandonment was announced, that would have likely triggered a rate case to be filed at the conclusion of that merger agreement. And so as that merger proceeding continued on, it still stayed that we would try to file the rate case in July of 21 for rates going into effect in 22.
Do you have a date, Mr. Monroy?
I don't, because there wasn't a distinct decision, and it was just as the rate cases were moved is when the bonds were moved in tandem with there. I know a set in stone date was July 29th or late July when Mr. Darnell agreed in the merger agreement that we would not file that rate case until June 1 of 2022.
At what, July 29th of what year?
2021.
So say it again.
So in July of 2021, PNM agreed as part of the merger proceeding to not file for a general rate case no earlier than June 1 of 2022.
Okay, so you definitely knew by July of 2021. Is that what you're saying?
Yes, by that date, the plans we began to update after that reflected the delay in the rate case, and the timing of the securitization bonds moved in tandem with that date.
Okay, and I think Ms. Hanassi asked you this, something along these lines, but just for clarity, from that point in time when you definitely knew that the bonds would be delayed to now, PNM did not make a filing at the commission informing the commission of that decision. Is that correct?
No, I'm not aware of any. I'm not aware of any avenue of which we would have informed the commission.
Yet you stated that the timing of the bonds was a requirement by the ETA. Is that correct, in order to obtain a financing order?
I stated that an estimate of when the bonds would be issued was a requirement.
Is it your testimony that a regulated utility can unilaterally change one of the express terms of a financing order without permission from the commission?
I can't speak to express terms but I agree PNM should be in compliance with the commission orders, and PNM is in compliance with the financing order. And
so you would say the timing of the issuance of the bonds is not an express term of the financing order?
The timing of the bonds, I think what I've said is what the financing order required was for PNM to provide an estimate of when those bonds would be issued.
And when that estimate changes, PNM is not, it's your testimony that PNM is not required to notify the commission or ask for a variance?
That is my testimony.
Okay, I have turning to an area exhibit SC11. I'm going to ask you for, there's a few exhibits, it's SC11, SC12, SC13, and SC14. I'm just going to ask you to look at them just to see what they are. SC 11.
There.
Are you familiar with
Miss-
this document?
I'm sorry, Ms. Gould, what document are you referring to?
NM Area Exhibit SC 11 NEE 12-12F.
Thank you.
And in this email, are you familiar with this document, Mr. Monroy?
I mean, it appears to be discovery responses that we filed.
Okay. Is it more communication plans?
Well, the first page, it looks like it is referring to something for Pedro-WRA. And that seems to be pages through page
Well, you could just look
5.
at, yeah, so are those like communications that PNM, like basically talking points?
I think that's a fair characterization of what's in this email.
Okay, so talking points, as if it was going to have a meeting with WRA, these would be the talking points.
Yes, that's what it appears to be.
Okay.
I'm not on these emails, but that's what this appears to be.
Okay, and then NM Area Exhibit SC 12 CCAE 14-8. These are the survey questions that were asked to customers regarding the delay of the bonds. Is that a fair characterization?
So we're on NM Area Exhibit SC-12.
Mm-hmm.
I mean, the first page says SJGS extension message testing and development. Is that what you're looking at?
Yep.
I'm not familiar with these.
You haven't looked at the survey that PNM sent to customers?
I did not.
Okay. And then NM Area Exhibit SC 13, I think we already went through with Mesur. This is the comms plan, is that correct?
Yes, that it appears to be what Ms. Zur asked questions about.
And these could also be characterized as talking points, is that correct? A communications plan?
I would refer to it as a communications plan.
Communications to whom?
I would have to go through all of it. I believe it was communications to stakeholders, customers, but I'm not 100% sure who it was intended for.
Okay. And then lastly, NM Area Exhibit SC 14. You may not be aware of this either. This is also questions from the survey that PNM put forth to customers. Are you aware of this?
No, I'm not.
Okay. So of the exhibits that we just looked through that you're aware of, the talking or that you saw, either the talking points to stakeholders or the comms plan, you are aware that PNM issued a survey, are you not?
I am. Yes, I am.
And are you also aware that they did focus groups on this issue?
Not aware of that.
Okay. My question is, if PNM always considered the time of the bonds to be linked to the rate case, why would it produce the talking points, the surveys, the marketing campaigns, the communication plans?
I mean, I think from a communication standpoint, the concept of securitization bonds, the concept of rate cases, they're all very complex messaging. And so the company, I believe, has a communications group to make sure that the messaging related to those issues are adequately communicated to our stakeholders.
And so, for example, the talking points for WRA, do you think that WRA does not understand securitization?
I can't speak to what WRA knows or doesn't know.
Well, if you're saying that the reason that the PNM is creating talking points is to help communicate a very difficult subject to the stakeholders, I'm just curious why it would create talking points to communicate this issue with WRA, do you think that they didn't understand what happened in the prior phase of the case?
If you're referring to SC-11, it appears these talking points were actually being provided to Pedro and not necessarily to WRA. And I guess I would point out that the company does communicate customer outreach all the time. I'm aware we're doing one right now for our grid mod application that we plan to file later this year. And so we do customer outreach all the time.
Okay, moving on to Pnm area exhibit 4. This is an excerpt from your direct testimony, or 2019 direct testimony in this case.
I'm there.
And this is a table, PNM table HEM4. This table basically outlines additional costs to obtain a financing order, and these costs pursuant to the ETA are allowed to be securitized. Is that correct?
Yes, that is correct.
Are the costs that PNM is incurring to litigate this phase of the case, are those costs going to also be included in this estimate?
I think they're eligible to be included. I don't know if the company has decided whether to include them.
And those costs would go and be securitized?
Yes.
Don't you think that's one of the reasons the courts have held for res judicata, so that parties don't incur legal costs twice?
Objection foundation.
I'll withdraw. In your testimony, you argue that the commission should not issue the rate credit because it's piecemeal rate making. Is that correct?
Sorry, I missed your question.
In your testimony, you argue that the commission should not issue the rate credit because it is piecemeal rate making. Is that correct?
I believe my testimony is they shouldn't issue the rate credit because it's not allowed under the financing order. And then I think I respond that because even under a hypothetical, because the ETA and the financing order does not allow that, then I further respond that under general rate making, it should not be granted because that is piecemeal rate making. But our first argument is it's not, the request under the show cause is not authorized by the financing order or the ETA.
One of your arguments is that it's piecemeal rate making, correct? And therefore it should not be authorized.
Yes, so that is, like I said, I addressed that as a second argument. Correct.
Okay, could you turn to Pnm area exhibit SC6?
Yes, I'm there.
Okay, and this is PowerPoints from a board of directors meeting dated March 1st, 2022. Is that correct?
Yes, it is.
Okay. And can you please turn to page 6 of that document?
Yes, I'm there.
And here on the second bullet point, there's only a couple sentences that are not blacked out. It says, plan assumes a general rate increase effective January 2024 with the approval of a generation and transmission and distribution rider that begins in 2025. You see that?
Yes, I do.
Is it fair to say that PNM was considering or is still considering proposing a T&D rider, T transmission, and D distribution rider in its next general rate case?
It is fair to say that was one of the assumptions
Okay,
that was being reviewed.
and that T and D rider would be piecemeal rate making, would it not?
It would have been a request included in a general rate case, very similar to, and I can't remember the dates, but maybe 10 years ago, where the parties actually agreed for a capital additions rider that ultimately was not approved, but a very similar kind of concept that was supported in a stipulation by parties. But that would have been something we would have sought a request for and asked approval for
And it would
in the
have,
general rate case.
and it would have been piecemeal rate making, correct?
It would have been a request to avoid future rate cases and pancaking rate cases. That would have had to have been evaluated in that case by all the parties in the commission as well, and whether that was a preferred rate making that the commission may want to adopt moving forward.
So is your answer yes, that it is piecemeal rate making, or no, that it's not?
Yes, it is. Generally, rate riders like the fuel clause and things like that are exceptions to the prohibition against piecemeal rate making that are authorized by the commission.
Okay. And then whether or not to engage in piecemeal rate making is a policy decision made by the commission, correct?
I would agree with that.
Okay, can you
But
please?
I guess I would also say that the commission shouldn't change its policy without giving adequate notice. And so that's why I believe asking in a rate case is giving adequate notice of going forward.
But the utility can change its position on when it wants to issue bonds without informing anyone?
Pursuant to pursuant to
So there's, go
my
ahead.
understanding, there's no requirement in the financing order to require when the estimate's changed.
So there's a little bit of an asymmetric relationship in terms of information, who shares what with whom.
In this example, I suppose. I mean, in those two.
I suppose would be yes.
Yes, sir.
All right, go ahead, Ms. Gould.
Thank you. Moving to, let me find my spot. I'm going to talk a little bit about the severance, the Section 16 costs. If you would go to page 6 of your, let me find it. Page 6, line 12 of your direct testimony 2022. You state that PNM is pre-funding the severance pay and the money for Indian affairs. Is that correct? You don't have to read, you know your testimony. Is PNM pre-funding the money for severance pay and Indian affairs, is that Section 16 costs?
The Section 16 costs, yes, we are proposing to fund at the time of abandonment.
Okay, and are you applying carrying charges to the pre-funded money?
I believe we were authorizing the financing order. Subject to check, I believe we are authorized carrying charges at Pnm's cost of debt.
For 25%, correct?
Subject to check, that's fine. I'm not sure exactly what the final, I didn't review that part, so I'm not 100% sure.
So you don't know what the cost to customers would be of those carrying costs over 18 months?
No, I have not done that calculation. And I think the abandonment, it would, under our current plan, it would be 15 months.
In your direct testimony on page 31, your direct testimony, your 2022 direct testimony, line 11.
On page 31, your direct testimony.
Sorry, in your direct testimony, comma, 2022, trying to differentiate it between the 2019 direct testimony. In your direct testimony on page 11, page 31, line 11, you state the funding of these job, training, and severance benefits are not tied to the timing of the issuance of the bonds. Is that your statement?
Yes, that is correct.
Can you please turn, do you have the ETA in front of you? If not, I have an exhibit that contains the portion of the ETA I'd like you to turn to.
I have the ETA.
Can you please turn to section 62-18-16J?
Yes, I'm there.
Says within 30 days of receipt of the energy transition bonds, a qualifying generating facility located in New Mexico shall transfer the following percentages of the financed amount of energy transition bonds as follows. And then it delineates the percentages from the bonds to go to which entity. Is that correct?
That's correct.
So my reading of the ETA is that the timing of these payments is directly and explicitly tied to the issuance of the bonds.
So the testimony you quoted is not referring to the section 16 payments under the ETA. That sentence is directly related to workers impacted by the closure of San Juan, so P&M and Pnm'S employees, and referring to their severance benefits. And so those employees are impacted will get paid out at the time of their severance. And so this isn't referring to the section 16 payment.
Okay. Thank you for the clarity on that. Has P&M also pre-funded the section 16 payments, just so I'm clear with what your testimony states?
No, we have not at this point. It's in my testimony on page 31, beginning on line 14, but no, we have not pre-funded those funds at this date.
So you've only pre-funded job training and severance?
We have pre-funded the job training and severance for the coal mine employees or the Westmoreland employees. Those were funded on March 3rd of 2022 after the Supreme Court decided on the appeal regarding this case. For P&M and San Juan workers, we have incurred job training costs. We expect to continue to incur those job training costs. As such, as the plan is not abandoned, we have not incurred the severance costs and those employees are still working there.
So I think that I'm confused. On page 31, line 14, you have a question that says, what's the status of P&M's funding for the state administered fund?
Please read it. Please read a little slower for me.
I'm sorry.
Page 31, line 14.
What is the status of P&M's funding for the state administered funds under the ETA? Are those the section 16 funds?
Yes.
And you said you're not pre-funding those?
Right. As I stated in there, after the Supreme Court delayed the proposed pre-funding, we worked with the state agencies with respect to the funding authorized, and we offered to provide the 25% at that time, so in Q1 of 2022, but each agency requested that P&M provide those funds at the time of abandonment.
So I guess when I'm saying pre-funding, I mean before the bonds are issued.
Oh, I apologize. Yes, the plan is to pre-fund before the bonds are issued.
Okay. And is it your testimony that those funds, those section 16 funds, are not tied to the issuance of the bonds?
They are tied to the issuance of the bonds. The bonds would require the funding to the agencies to happen 30 days after the bonds are issued, but P&M has agreed to provide the funding at the time of abandonment, the pre-funding, as you call it.
What authority does P&M have to issue these funds before the issuance of the bonds?
I don't have the exact quote, but I thought in the RD, and I could look for it, but I thought the commission ruled approving our pre-funding and had a sentence in there, I had a comment saying, and if more funds can be made available sooner, then they should do so. But I know that's not an exact quote, but I believe that's in there somewhere.
Let's turn to page 102 of the financing, of the recommended decision on financing order. I don't know if this is what if this is what you remember. I'm just going to read from page 102. I'm on the second full paragraph. The hearing examiners recommend the adoption of Pnm's proposal with the respect to the job training costs for Pnm and the severance and job training costs for the coal mine employees. The hearing examiners also recommend that Pnm's request for approval to make 25% of the Section 16 payments in advance, consistent with Pnm's most recent proposal, be approved. The hearing examiners further recommend that Pnm be approved to pre-fund the total of the Section 16 payments to the extent the state agencies administering the funds inform Pnm that the agencies can productively use the funds prior to the plant's abandonment. These approvals acknowledge both the uncertainty associated with the potential closure and the importance of providing assistance to the displaced workers in the San Juan community. Is that what you're referring to?
That is what I was referring to. Thank you.
Okay. Under traditional rate making, would you have to make these payments on abandonment?
No, these were Section 16 payments specific to the Energy Transition Act.
And if Pnm decides not to issue the bonds after all, what happens to this money?
I don't know, as that's not our plan. So
would customers have to pay for it?
I don't know. Pnm's plan is to issue the bonds, so I haven't thought through that hypothetical.
In your direct testimony, as we just went through, you said that Pnm offered to provide 25% of the funds to the agencies, but each agency requested that Pnm provide all of the funding at the time of the abandonment. Is that correct?
That is correct.
Why do you think the agencies wanted Pnm to provide all of the funding at the time of abandonment?
I don't know. I wasn't involved in that discussion.
Do you have an idea?
I don't.
Can you pause one moment?
Sure.
Starting to choke. Sorry about that. Thank you.
Could you please, do you have any knowledge of the concept of the time value of money?
I do know the concept of time value of money.
Could you just describe what that concept is?
That concept reflects that $1 in the future may be worth something than $1 today.
Maybe worth something?
Something different, sorry.
That money is worth more now than it would be at a future date?
Generally, that's correct, because you would take a future cash flow dollar and discount it back to a present value, which would be lower.
Okay, on page 13, line 13 of your 2022 direct testimony. You state Pnm's preliminary analysis of requested rate increase if Pnm had filed a general rate case in June 2021 with rates effective July 2022 have been in the range of 23 million to 36 million base rate increase. Is that correct?
Yes.
Okay. And are you familiar with Rule 530?
Yes, generally, yes, I am.
Let me get the whole rule up. You can pull up NM Area Exhibit SC20, and that rule citation for the record is 17.9.530. And Rule 530 lists many data requirements that are required, the commission requires in order to ensure that rates are set, the rates that are set are just and reasonable. Would that be accurate statement?
I agree with that, characters. I agree with that.
Did PNM file any of the schedules required by Rule 530 to substantiate the numbers you have in your direct testimony?
No, PNM was responding to a show cause motion. It was not filing a general rate case.
So there's nothing to substantiate that these dollars of between 23 million and 36 million.
We did provide the capital spending that we've actually incurred from 2019 through 2021. We provided projected capital spending for 2022 and 2023 as information, and we provided our projected rate increases as responding to the show cause motion. But you're correct, we did not request the commission to change rates in this application.
There's not enough data in this application to be able to see if those numbers are correct.
That is correct. And that is also why the relief requested under the show cause motion, we believe, is not appropriate, as there's not enough data to determine that the rates that would be charged then would be just and reasonable.
Ms. Nanasi was talking about the revenue requirement going forward. Basically, when you set rates, you made a cost of service analysis, and the costs for San Juan were in there. And Ms. Nanasi was asking you to bring forward those costs, and you said that that's not possible. That's not how we do rate making. Is that more or less the discussion you had with Ms. Nanasi?
Sure. Yes. I mean, I don't know. That was a lot of concepts in there.
Could you describe to me how PNM calculates its RPS rider?
The RPS.
Is it based on the cost of service for the last rate case?
Is that the renewable rate rider?
Yes, it is.
So the renewable rate rider is based on a cost of service that I believe is updated annually every year, reflecting the on-year revenue requirements. I think it's a projected revenue requirement for that year. And so I believe that rider is included in the procurement plans. It's filed in the summer of each year. It's approved prior to the beginning of the next year. And so that rate goes into effect. And then I believe there is a true up that is performed. And that true up, that rate for the rider either goes into effect in February or April. I'm not 100% sure on the dates.
It would be a different mechanism than how you were describing the traditional rate making mechanism with Ms. Nanasi. Is that correct?
Yes, like I discussed, the legislature and the commission can create exceptions to piecemeal rate making. I believe the legislation for the renewable rate rider, or the RPS, indicated a rate rider. Similar language was included in the grid modification statute that also indicated a rate rider, or base rates may be sought to recover those investments.
Do you know if PNM supported those statutes when they were up at the legislature?
I don't know.
And so if a statute allows for piecemeal rate making, then it's okay?
If authorized by the legislature, as they set the policy of the state.
Okay, I think that is all of my questions. Thank you, Mr. Monroy.
Thank you, Ms. Gould.
Thank you, Ms. Gould.
Excuse me?
We are at,
Mr. Hearing examiner, can I just go through my exhibits to see if there's anything I want admitted?
Yes.
Thank you.
And Ms. Nanazi,
That's
is that
what I-
you?
Yes, thank you, sir. That is what I was going to ask Ms. Gould. Thank you.
You're on mute, Kelly, if you were trying to speak.
Thank you. Mr. Hearing Examiner, I would ask that NM area SC11 be admitted.
Is there any objection to NMS, to New Mexico area D-11?
Mr. Hearing Examiner, this is a 30-page exhibit. It wasn't delved into beyond really the first couple of pages. I don't have an objection to the first, I guess it's actually through page 5, which is what was gone over.
Yes, that's fine. I just included the whole exhibit because I didn't want PNM to say that it was incomplete exhibit. So just to page 5 of 30. Thank you for that clarification.
So what you're seeking the admission of is NMS, New Mexico area SC11, pages 1 through 5.
That's correct.
Any objection to that?
No objection from P&M.
Any objection from anybody else? Hearing no objection, New Mexico area SC-11, pages 1 through 5 is admitted.
And I would also seek to admit NM area exhibit SC6, but I'm not sure. I think it may have already been admitted by Steve Michael.
The long-range plan.
The, yeah, 20, it's,
The 2022,
it's NEE 12-1.jc.
It wasn't admitted by Mr. Michael.
It was not?
No.
Okay.
So we're talking about NM area SC6.
That's correct.
No objection to that.
any objection from anybody else? Hearing no objection, NM area SC-6 is admitted.
Thank you.
Any others?
No, that's all.
Okay. We, Mr. Marks, Sierra Club is up next. Do you have 20 minutes with Mr. Monroy?
I don't think so. I think I'll be done by 3.
Okay. Whenever you're ready.
Good afternoon, Mr. Monroy. Page 14 in your direct where you calculate impacts of rate case drivers.
Yes, sir.
That's calculated with the return on equity from the 16-276 case, 9.575%, correct?
That is correct, sir.
Have you ever calculated the equivalent table to this HEM2 using a lower ROE?
I have not.
Okay. Are you aware that in case 20-00104 UT, which is El Paso Electric's most recent rate case and the most recent litigated large electric utility case, the commission awarded an ROE of 9.0%?
I'm not aware of the details of that case.
So you have no knowledge that the commission's been awarding ROEs below 9.5%?
I do know they have gone lower than the 9.575. I just didn't know it was 9.0 or if that was stipulated to or any type of agreement on how they set that ROE. That's what I mean when I don't know.
So it's not one of your responsibilities as a key person in the rate department to follow the significant developments for EP and SPS?
No, that the regulatory group does that.
Okay. All right. And then so you're also unaware then in that El Paso case that Commissioners Fishman and Hall filed a concurrence indicating that 9.0 they thought was too high?
I'm not aware of that.
Okay. And then you didn't make any adjustments in your HEM2 for changes in billing determinants, did you?
HEM2 in this case that I filed is just a revenue requirement, so I did not. There's no billing determinants in my HEM-2. No, that is based on the cost of service amounts included in that case.
Okay. You would agree with me, though, that changes in billing determinants have an impact on the actual revenues that the company recovers.
Of course.
Okay. And it sounded like, based on what you included in your direct and what you talked about with Mr. Michael, that the billing determinants are up from 16,276. Is that correct?
Yes, I do believe that the billing determinants are higher than what was in the 16,276. I'm not sure how that breaks out amongst customer classes.
From what I heard, okay. But if they're higher in aggregate, then that would result in a lower, it would have the effect of lowering the rate per kilowatt hour, correct?
As a single item, if that was the only thing that changed, all else things constant, then yes, increased billing determinants would result in a lower rate.
Okay. But when you were doing this, and it looks like this is fairly consistent with some of the internal analyses you did, you just assumed that you just ignored the prospect that the ROE could be reduced or that or the impact of changes in billing determinants on what customers would pay.
One of the assumptions is we kept the ROE constant. Those requested rate increases do reflect the change in billing determinants or changes in load under what we would ultimately need to request from customers.
Which requested rate increases?
The 23 million to 36 million.
I thought you told me something different, that these were revenue requirements and they weren't rate increases.
I thought you were referring there to HEM-2 as my, I apologize. I thought when you said HEM-2, I went to the exhibit that quantified what was in rates, what was in our last cost of service. I didn't know you were still sticking with table HEM-2. That is my apology.
Okay, so, and I'm sorry, hopefully we'll still get done by 3, but so they're all on the same page. HEM-2 says it's rate-based drivers, and the revenue requirements, we've got 2 columns there, and the range of revenue requirements total to 23 or 36, correct?
Yes, sir.
Okay, and it says a rate increase. Is that a rate increase or is that a cost of service increase?
That is a rate increase. I apologize. It does account for the change in load that we were projecting at the same time.
Okay. It just doesn't. And is there analysis that enters into this that's somewhere in this case that shows that?
I believe in a discovery response to WRA, they asked for supporting work papers, and I believe we gave them the underlying more detailed drivers.
Okay. And then in your direct testimony, you indicated that the Avangrid merger stipulation was a reason why the company's rate case filing is going to be delayed. Would you agree?
Yes, sir.
Okay. And you've called it a merger commitment, is the term you've used. Is that right?
Yes, sir.
Okay. But you would agree with me that a delay or date of a filing of a rate case or any delay in a rate case, that's not in the filed stipulation, is it?
No, as I put in my testimony, or maybe it's not in my testimony, but it was included as an agreement agreed to by Ron Darnell. And I believe in his rebuttal testimony that we would agree to not file for a rate case before June 1st of 2022.
And who did he make that agreement with? He didn't make that with any of the counterparties to the stipulation, did he?
I don't know who he made that with. I think it was in response to maybe Bernalillo County's witness, but I'm not 100% sure.
Would you agree with me that there were a couple of witnesses, one of whom was I think a CCA witness or in that group, who indicated that rate freezes were typical in a merger, and then I think there was another witness, and Mr. Darnell responded to that by making a concession in his testimony, adding a sweetener.
I wasn't involved in the merger, and I didn't read that testimony or all of those testimonies in great detail.
Okay, but you'd agree with me that this was not bargained for in the stipulation that was submitted to the commission?
I'm not as adept into the merger. I know it wasn't in the in one of, I think, the June 4th stipulation, but then it was included, like I said, in the rebuttal testimony, and then moving forward, it was included as the ultimate merger commitments in that case.
Commitments, again, you testified about this subject, and I think what you're saying, which is I would agree with, is that PNM made this as a voluntary commitment in the case. It did not bargain for it with the parties. Is that consistent with what your understanding is?
No, that's not what I said. Like I said, all I know is that we agreed to it in rebuttal testimony.
Okay.
And Mr. Darnell.
And then following the close of the testimony, the hearing examiner, he recommended that if the stipulation or the merger was to be approved, that the rate freeze should be extended. Is that correct?
That is correct. I believe he recommended it for another 6 months through December 1st, 2022.
Okay. And PNM decided that, according to these internal communications, that it would go along with that, correct?
I'm not sure what internal communications you're referring to, but in our certificate or exceptions to the stipulation, I know I'm not saying that right. It's in my testimony. We agreed to that provision.
Well, isn't that what I think Ms. Zura was asking you about when you called it the HE path?
I believe that was questioning from Ms. Nanasi.
Okay.
On one of her discovery requests, and we were referring to those questions. That is correct.
Okay, so the HE
it was
path
tied to the certification of stipulation from the hearing examiner in the merger case.
Okay. Nothing further.
Thank you, Mr. Marks. All right, appreciate it. We are going to take a sticky mouse here. I'm trying to get that off. I'm sorry. We're at 3 p.m. and I'd like to take a 15-minute break. Let's come back at 3:15. The Attorney General is up next, Mr. Gedko. Yes, sir.
Mr. Hearing Examiner, due to the scheduling constraints of myself and Gideon will be joining after the break if you're able to meet him and I have to drop
Yes.
off.
Thank you, Mr. Gedko. I'll be looking for him. All right, let's come back at right at 3:15 or so to resume the cross-examination of Mr. Monroy with the Attorney General's cross-examination. Thank you. Right. Good afternoon. We're back from our afternoon break. Mr. Elliott, for the Attorney General, do you have questions for Mr. Monroy?
I do, Mr. Hearing Examiner. Yes.
And I have you down for 15 minutes. Is that accurate?
It is accurate. I absolutely will not be using 15 minutes.
Okay, please proceed.
Good afternoon, Mr. Monroy. How are you?
Good afternoon.
I just wanted to ask you a few questions about the depreciation expenses and how they're going to be calculated for after the Unit 1's abandoned on June 30th. The amount that's going to be securitized, it's the net book value as of June 30th, right?
For Unit 1, that's correct, sir.
Okay. And for Unit 4, that's being abandoned September 30th, right? That's September 30th, right?
That's correct. Unit 4 and common equipment.
Okay. So the net book value on Unit 4 at September 30th is going to be lower than the net book value of Unit 4 on June 30th.
That is
right?
correct.
Okay. So between July 1 and September 30th, there will be additional depreciation expense booked that will reduce the net book value on Unit 4, right?
Correct. As it remains used and useful. That is correct.
Okay. So how is PNM going to calculate the amount of depreciation expense to book to Unit 4 between July 1 and September 30th? Is it going to use the depreciation expense that was authorized in the last base rate case?
No, depreciation expense is based on the approved depreciation rate for whatever asset class that the plant is recorded in, times the gross book value. And so our accounting systems actually calculate the depreciation expense based on what those actual balances are and what the actual approved depreciation rates are.
Okay. Okay. That's all I have. Thank you.
Thank you.
Okay. Next up. Thank you, Mr. Elliott. I was presuming that's all you have for the witness entirely, correct?
Yes, sir.
Okay. Ms. Chappelle for the San Juan legislative delegation, do you have any questions for Mr. Monroy? Yeah, please unmute yourself.
I knew I would do something silly. Sorry about that.
No worries. We all do it. Or most of us, at least.
I was just excited. I figured out how to turn my video back on. So.
Okay, I have you down for 10 minutes with
Yes,
Mr.
sir.
Monroy. Okay. Please proceed.
Thank you. How are you doing? This has been a long day for you, Mr. Monroy.
I'm doing good. Thank you for asking. How are
Yes.
you, Chappelle?
Good. Thank you. I just had a couple clarifying questions. I think it was earlier in your testimony or answer to questions with Mr. Michaels. There was a conversation, if you recall, about load growth. And I think you said during COVID, you had a downturn in load growth.
So during COVID, it was in regards to decoupling and What we saw was an increase in usage per customer for our residential customers. And we saw a decrease in electric sales in our commercial classes.
Okay. And I was trying to tie that to your testimony, page 18, that just referenced generally load growth. And so I was trying to square that. And so that helps me better understand. So overall, now that COVID is fading away, are you guys seeing load growth again on the commercial side?
And sure. And so the load growth here, obviously, yes. What we have seen is a return to more normal usage patterns on our residential customers, that the usage has gone back down to pre-COVID levels. And we've seen the increase on the commercial side of sales.
Okay. So probably a return to work issue.
That was especially on the residential, it very much felt that because people were home all the time, their usage increased.
Okay, so, and thank you for that clarification. What that leads me to conclude then, and I want to get your take on this, is we're not necessarily seeing new load growth. It's just an adjustment due to patterns in working from home type thing.
That's a question. I'll defer you to Mr. Setledge.
Okay.
He's probably got a better handle on the load
Appreciate that.
than myself.
Going back to the conversation you had earlier on the job training benefits, can you give a little more detail, and just to refresh your recollection, it's on page 31 of your testimony. Can you give a little more detail to the extent you know on what those job training benefits are and how many employees roughly are taking P&M up on the job training benefits?
I don't have the details related to the job training benefits of what they've actually incurred. I believe a very small dollar amount has actually been expended through March of 22. We had estimated around $200,000 for job training that's been incurred so far. Regarding to there, as far as benefits and severance, like I said, those we wouldn't expect to have paid out yet. As those will get paid out once the severance actually occurs at abandonment.
No worries, Mr. Monroe. I was really only looking at the job training benefits.
Okay.
What is the amount potentially that P&M projects to spend on job training benefits?
So at this
on employees, sorry.
Sure. So originally we had estimated $1.3 million based on the decline in employees through natural attrition. We are now estimating to spend approximately $700,000.
Okay. So a decline of about 600,000.
That is correct.
Okay. Thank you. Now, if same page, arrange the discussion about P&M going, having the back and forth with state agencies on funds going to the community and the 25%. Do you have an understanding of the reason why agencies offered or agreed to not take the 25% up front?
I do not. I do not. I wasn't involved in those conversations.
And are there any of the other witnesses that P&M is proffering in this case or in this matter? Would they have a better idea? Do you know?
No, I don't believe they would.
Okay, thank you. My last question, and for some reason I can't see the time on my screen. I think am I okay on time, Hearing Examiner Medeiros?
Yes.
Okay, thank you. Oh, look at me going super fast here. Just kidding. Okay, so Mr. Monroy, one of the things that's been curious to me about, the circumstances P&M is currently in, particularly with the need for P&M to keep San Juan Generating Station open for an additional 3 months, and kind of your perspective and position in projecting forward. Can you see any need moving forward to keep San Juan Generating Station open longer than the 3 months?
That's a question that's really beyond my scope. That'd be better served as of, Mr. Falgren, who's our generation.
Okay. And then with respect to that, from your standpoint, your lens on the finance side of things, is that potentially those unknown circumstances, is that potentially a reason also for pushing out the rate case and also the financing decision on issuance of bonds?
It's not in my mind.
Can you just help me understand why it's not in your mind?
Sure, because the decision is really tied to when we would be filing our rate case. And as we said, we plan to file it in December of 2022 with rates to go into effect in 2024. And so the underlying resource issue I think you're asking about isn't a factor in that decision.
And what about with respect to issuance of the bonds and the financing order?
So then, as we stated in our testimony, the issuance of the bonds would coincide with the effective date of rates in our next rate case. So we anticipate issuing those bonds at the end of 2023.
Okay, I don't think that actually answers my question with respect to what role, if any, the potential volatility in the market and the need potentially for some of these resources to stay online impacts the financing order. That's really what I'm trying to get at.
And I don't think the status of the resources have an impact on our decision on when we would file the rate case and issue the bonds.
Okay, so you're saying they're completely separate?
Yes.
Okay, thank you. That's all the questions I have. Hearing examiner.
Thank you, Ms. Chappelle. Mr. Albright, I have you down for Bernalillo County for 15 minutes.
Yes, Mr. Hearing Examiner. Good afternoon, Mr. Monroy. I'm Jeff Albright with J. Albright Law LLC and representing Bernalillo County for the record. Been a long afternoon. I was absent for a portion of the afternoon queries with the commitment that I had. So if I ask a question that's already been asked and answered, I would ask you to let me know, and I'm sure that Mr. Alvidrez won't hesitate as well, but I don't want to take up unnecessary time by repeating questions that may have been asked during my absence. I'm primarily going to focus on your direct testimony. I may have a few other questions on the rebuttal and so forth, but we'll focus primarily on that. I may also ask some questions from the deposition of Mr. Terry, where he referred a few questions be directed in toward you, better answered by you. So we may do that, and I believe that's Bernalillo County Exhibit number SC-26. So if you don't have the deposition handy, that can be referred to. So first, I'd like to start with your direct testimony at page 3, lines 13 to 14, and just ask, you state there that the PNM is also filing a legal memorandum in support of its legal positions in this case, which addresses question 20. Do you see that?
I apologize. I missed your page reference.
I'm sorry, page 3, lines.
Got it. Thank
13
you.
and 14.
Yes, sir.
Okay, did you assist in the preparation of that legal memorandum with your counsel?
No, I did read it after it was written before it was filed, but no, I did not.
Okay. And in looking at page 4, turning to page 4, lines 10 through 12, it stated that PNM acknowledges that at the time it filed its consolidated application for the financing order, that it anticipated it would issue the energy transition bonds near the time of the abandonment of San Juan. Is that correct at the time?
Yes, sir.
Okay, so I have a question with regard to looking at PNM table HEM-4. I think that's at page 18 of your testimony. Mr. Michael this morning asked you some questions about that, and I just want to be clear in looking at that table. When it refers to the year 2018, is that as of December 31st of 2018?
So the earned returns are based on the calendar year. So it'd be the 12 months ending December 2018, under which that return would be calculated on.
Okay.
So it's an annual period.
All right. And so 2019 would be through December 31, 2019, correct?
Yes, sir.
All right. And 2019 in particular, the COVID, as I recall, began about March 11th or March 13th in that time frame of that year. And so you were over earning above your ROE for 2019, correct?
I believe COVID began in March of 2020. I mean, I've tried to block it from my memory, but I believe that's when the pandemic began.
Well, let me just move forward.
Well, it just
Memory is fleeting when it
pandemic-
comes to COVID. We wish. So I hear you. I certainly understand. But would you agree that for 2019, at least the number listed here, that it exceeds your authorized ROE for that year?
Yes, that is correct.
What, just hypothetical, what do you think would happen with the Public Regulation Commission if you came in for a rate increase during a period where you had earnings above your ROE?
It's really hard to compare the two. You know, we've moved to a future test year where we project our costs based on what our costs will be when rates go into effect at the conclusion of that rate case. And so it's really hard to conclude anything on what the rate should be based on a future test period, based on what rates were in the past.
Okay, so in lines 6 through 8 on page 18, where you talk about that the system improvements, new investment, general inflation, which would increase customer rates, have been offset by load growth and declining costs. Could you expand on what both the load growth and the declining costs were during that period?
I don't have them specifically. I don't have them by year. But, you know, in preparing this case, I did notice that the retail revenues, what we charge our customers, was higher than what our revenue requirement was when we set the rate. So we had a positive pickup in revenues from load growth. The declining costs, those include, for example, reductions in our weighted average cost of debt as interest rates have declined. And so our weighted average cost of debt is become lower than when we set rates, as a couple of examples. And then also, yeah, I think those are the two big ones. Those are the ones I wrote my notes on. So.
All right. And I'd like we'll get to interest rates here in a little bit as well. If you go back to page 4, lines 18 through 20, you mentioned that PNM also delayed the filing of its next rate case in consideration of the proposed merger with Avangrid. Would you explain that?
Sure. So as I explained a little bit later in my testimony, PNM, so when PNM filed the merger commitment, it was unlikely that PNM wouldn't file for its next rate case until the conclusion of that merger proceeding. During the merger proceeding, PNM agreed to certain merger commitments that would defer the filing of PNM's next rate case, initially both to June 1 of 2022, and then ultimately agreed to December 1 of 2022. We would not file a rate case prior to those dates.
And the position with regard to the securitization, in most cases, my understanding of securitization is that for people who are buying the bonds require that any successor in interest, whether it's through a bankruptcy or merger, has to agree to the conditions or should say that it influences the securitization of the bonds. Is that a fair statement?
Could you ask that again? I'm not sure I followed.
Yeah, that wasn't as worded as well as I probably should have. My understanding is that in the event of a bankruptcy or a merger and acquisition, that part of the securitization process is that the anticipated buyer, either out of bankruptcy or in a merger situation, has an impact or has to agree with regard to the securitization that occurs. Is that a fair statement?
I'm not sure I can answer that question. I know that the ETA requires a non-bypassable charge, but perhaps Charles Atkins, who's a witness in this case, may be better suited to respond to that question.
Okay. Do you have any idea what the impact will be of the proposed merger with Avangrid have on the cost of the securitization, if any?
I don't see how the merger would have an impact on the cost of securitization.
On page 8, but just a general question. When's the value of the abandoned assets removed from the books of P&M? When does that occur?
I'm trying to read just quickly on page 8 what value are you referring to?
I'm specifically just in general with regard to the securitization, and when the plant is officially abandoned, when are those assets removed from P&M's books?
Oh, I understand. So at abandonment, P&M will remove the undepreciated investment related to San Juan, record them to a regulatory asset. Upon issuance of the bonds, though, that regulatory asset will be transferred to a special purpose entity. I mean, the SPE is still an entity within P&M, so it'll always be on P&M's books, but it'll be recorded to a special purpose entity and transferred over.
Does P&M anticipate that any of the generation for San Juan will be sold as merchant capability or as merchant asset capacity?
Mr. Hearing Examiner, I'm going to object as to relevance to this proceeding.
Mr. Albright, what's the relevance?
I think it's very relevant, Your Honor, in that if it's sold for merchant, you have ratepayers who are continuing to pay because it's in base rates. And if the merchant plant is sold in the open market, there's additional revenue that comes in to that benefits P&M more likely than not.
Overruled.
So there is 65 megawatts of San Juan Unit 4 that is not included in retail rates. Those 65 megawatts of Unit 4 will continue to be available until San Juan Unit 4 closes.
And generate revenue for P&M, correct?
We do sell that power in the off-system sales market. We also cover all the operating costs associated with the 65 megawatts, as those aren't included in rates. We being P&M, excuse me.
On page, Mr. Hearing Examiner, could you tell me how much time I have left?
3 minutes.
Thank you. On page 22, lines 3 to 6, what is the likelihood that all San Juan replacement resources are going to be online and available? That's one of the presumptions that's made, or at least is stated there.
Yeah, so currently we have had to, what's included in the 2023 does reflect certain delays in the San Juan replacement resources that are being available, that is included in the 2023 estimated fuel costs. So it has included for some delays.
And where's that reflected in your testimony?
So the results is included in P&M exhibit HEM-10 of what our projected 2023 fuel costs are based on the assumptions.
And that's with the additional delays in both supply and other construction, correct?
Right, that did reflect delays of the San Juan resources not being available through the summer of 2023. No, I apologize on that. It did reflect certain other resources were still projected to come online at the end of this year, so they would be included in 2023.
So page 23, lines 1 to 4, where you talk about ESAs, how much of the 300 megawatt of San Juan replacement resources are comprised of ESAs, the service agreements for battery storage facilities?
It's the 300 megawatts. Or maybe I don't understand your question.
With regard to impact on revenue.
I'm not sure I understand your question.
No, given the limits of time, I will move on with that. And we kept talking about a rate case being done. That rate case would be for a future test year, correct?
That is correct.
And so how would the abandonment of San Juan, the value when it's removed from the books, be carried forward as part of the future test years? That because you would claim it as a regulatory asset?
No, the undepreciated investment would not be included in our request for setting base rates.
On page 23, lines 1 through 4, if all of the ESAs are not available, does P&M anticipate it will have to buy energy on the open market in 2023?
I have heard that, but I think I'm not the most perfect witness for that question, but that is my understanding. That would be, he'd have to serve load.
Who would be a better person to ask that of?
I would refer to Tom Falgren, who's our VP over generation.
And I don't think he's a witness in the case. Okay.
Mr. Albright, with the time's elapsed, do you have any more questions? Do you want to take some time from another witness?
Yes, let me go ahead and take some time, bear with me here. Let me take 5 minutes from Ms. Sanchez and move them to Mr. Monroy, please.
Ms. Sanchez, thanks you. Okay, go ahead, 5 minutes.
And Mr. Monroy probably doesn't, but.
It's all good.
Okay. And the estimate on, I don't have the page, you state that there's an estimate of $23 million per year for 25 years to pay the debt service on the energy transition bonds. Do you remember having made that statement?
Yes, it's on page 23.
23.
The page we were just on, so.
Okay. And is that estimate still correct, or is still the best estimate you have?
It's the best information I have, yes.
Okay. On page 24, lines 7 to 8, you talk about what is meant by large swings there. You say that there could be large swings if you give a rate credit and then turn around. So what do you mean by, what's your definition of large swings?
So I believe witness Setledge actually quantifies what the swings would be. I can't remember exactly what percentage changes he quantified in his testimony, but I would refer you to Mr. Setledge to quantify those, but they were quite large percentage changes that he quantified.
Okay, I'll defer that question to him. On page 27, and it's been the discussion with a number of the witnesses today, lines 18 through 19. You say that there's no allowance under the financing order for the rate credit to be implemented upon the abandonment of San Juan. you see that?
That is correct.
Okay, and that's your position.
That is correct.
Is there anything that precludes it from being part of the financing order, that a rate credit be issued?
As part of the financing order, the financing order is done and complete. And so I don't believe it's appropriate to modify the financing order as issued.
Anything under the Energy Transition Act that precludes the commission from providing a rate credit?
I believe the Energy Transition Act identified the proposed rate making that would happen or required the commission to approve the proposed rate making that would happen upon the issuance and beginning the collection of the energy transition charges, and if base rates had not been adjusted to reflect the abandonment of the qualifying facility. And the financing order approved that rate making mechanism, which does require an interim rate credit to go into effect upon implementation of the energy transition charges.
But my question was, is there anything in the Energy Transition Act that precludes the commission from making that determination of a rate credit?
No, and I guess because like I said, the commission has already approved the rate making mechanism that should be applied once the bonds are issued.
On page 33, line 17 to 22, you talk about interest rates being lower at the end of 2023 than any time in 2022. Do you still believe that to be true?
Yes, I was referring to Pnm witness Atkins' testimony that confirmed that forecast that interest rates would be lower at the end of 23, lower than any time. And that is based on Mr. Atkins' testimony.
Okay, so that's not your personal opinion. You're just quoting Mr. Atkins, correct?
Yes, I believe I even said Pnm witness Atkins' testimony confirms. It's my opinion that I read his testimony and saw the rates he quoted.
1 minute, Mr. Albright.
Thank you, sir. On page 44, line 16 to 18, and you have that, particularly in line 17 and 18, you say the PNM has yet to begin recovering its substantial system investments since 2018. Do you see that language?
Yes, sir.
What system investment since 2018? Given the delays with the renewable replacement portfolio.
Sure. So I provide a table in my direct testimony that identifies, let me get you there, between generation, transmission, distribution, and general and intangible capital investments that we've made. And that's on page 16. The Q&A actually starts on page 15 of my direct and goes through pages 17 where I discuss those capital investments.
And do you think that's still the information you have there is still correct and current?
Yes.
Okay, Mr. Hearing Examiner, I have no further questions for Mr. Monroy. Mr. Monroy, thank you very much. Appreciate your responses.
Thank you, Mr. Albright.
Thank you, Mr. Albright. I don't know whether the parties can hear me, but my video is frozen right now. So I think I might have to log off and log back on before, if you can hear me.
We hear you just fine.
We can hear you.
Yeah, my video is frozen. If you can see probably my screen there. That's not a scowl. That's just
okay.
Thinking, what the heck's going on here? So what I'm going to have to do before we start back up with Mr. Borman is exit the Zoom meeting and come right back. So I might have to shut down my system. Apologies for this. It happened earlier, but it was just a minor glitch. But right now it looks like the video is completely frozen. So let me do that. And again, apologies. Okay, hopefully I'm back.
You are back.
Interestingly or not, Zoom decided to install updates on its own. So that hopefully was what was going on there. Mr. Borman, I have you down for 30 minutes. And again, apologies for that glitch. But Mr. Borman, you have 30 minutes for staff with Mr. Monroy.
Thank you. I expect I will use most of it, but probably not all of them.
That's fine. You have 30 minutes. Go ahead.
All right. Thanks. Good afternoon, Mr. Monroy.
Good afternoon, Mr. Borman.
Pnm's most recent rate case was heard in case number 16-00276 UT. Is that correct?
Yes, sir, that is correct.
And you were a witness in that case, is that correct?
That is correct.
Okay. And that case was filed in 2016 with a 2018 future test year, right?
That is correct.
And a final order in that case was issued in, I believe, January of 2018. Is that correct?
That sounds correct.
And Pnm's current base rates have been in effect since that time, correct?
That's correct. They were phased in over 2 years, but yes, that's correct.
Okay. Do you remember if there were any outstanding issues in that case which were to be dealt with in a subsequent rate case?
Not specifically.
You don't?
I'm sure there were, but.
Okay. Do you remember any issues of prudency that were outstanding from that case? And not specifically related to San Juan necessarily.
Right. I believe Four Corners, if you're referring to Four Corners, I believe that was an outstanding issue.
Okay. Now, when Pnm implemented the rates established in 16-00276.
I missed you. Can you get that question again?
Yes. When Pnm implemented rates established in case number 16-00276, Pnm was recovering a return on investment, depreciation, and property taxes on Pnm's investment in San Juan units 1 and 4 through its approved base rates. Is that correct?
Yes, sir. That was included in our test period cost of service. That is correct.
Okay. And Pnm is currently recovering a return on investment, depreciation, and property taxes on Pnm's investment in San Juan units 1 and 4 through its approved base rates. Is that correct?
I mean, Pnm's rates are based on that test period cost of service. And so as I've testified, the rates aren't necessarily reconciled back to any one specific item that was included in the cost of service upon which the rates are set on.
Well, that didn't answer my question. So is Pnm currently recovering a return on investment, depreciation, and property taxes on Pnm's investment in San Juan units 1 and 4 through its approved base rates?
San Juan units 1 and 4 were included in the cost of service on which rates are set on.
And they are still included. They are still included. Is that correct?
Sorry. Yes, there's been no change to Pnm's base rates.
Okay. When will Pnm no longer be recovering return on investment, depreciation, and property taxes on its investment in San Juan units 1 and 4 through its base rates?
So Pnm will seek to reset its base rates through a general rate case. That plan is to happen plan to make that filing in December of this year with rates going into effect in 2024. The reason I paused on your question is, once again, rates, you're trying to single out San Juan in rates. But like when we do the earnings test, we use whatever the current rate base is to determine, are those rates covering both what was previously included in rates minus its accumulated depreciation plus new investments that we've made that are serving customers but have not yet been reflected in rates. And so that's my pause in trying to answer or clarify your question, Mr. Borman. And I believe you're trying to link that rates are reconciled to the specific assets, and that's not how general rate making works.
In response to a question from Counsel for Western Resource Advocates, you stated, and this is paraphrased from my notes, Pnm's rates are just and reasonable and will remain so until Pnm files for an adjustment in rates. Do you remember making that statement?
Subject to check, that's fine.
That's a fair representation of what you said.
Sure.
Okay. Is it your understanding that upon the filing of Pnm's next rate case, Pnm's rates will no longer be just and reasonable?
No, that is not my understanding.
Okay, Pnm's not the arbiter of whether its rates are just and reasonable. Is that correct?
That's correct. They're determined and set by the commission.
Okay, so it's a more accurate statement that Pnm's rates are just and reasonable until the commission determines otherwise.
I could agree with that.
Okay. On page 4 of your direct testimony in this matter, you state that Pnm delayed filing its planned rate cases primarily because of the COVID-19 pandemic in order to not negatively impact customers struggling with the economic fallout of the pandemic. Is that correct?
Yes, sir.
So is it correct that the decision to delay the filing of the planned rate cases was not a decision made personally by you?
That is correct.
Who did make that decision?
The decisions on the timing of a rate case are made by our executive policy committee.
Okay. And who is that executive policy committee?
Currently, it is Pat Vincent Colon, Don Terry, Ron Darnell, Chris Olson, Patrick Apodaca, and Charles Eldred.
Okay.
That should be 6 individuals if that's one.
So was that executive policy committee that made the decision?
Yes, that is correct.
Did you provide a recommendation to the executive policy committee regarding the question of whether or not to delay the planned rate cases?
Regarding COVID, I don't remember preparing any specific analysis. I think I don't recall preparing any specific analysis other than during a pandemic, it probably didn't make sense to file for a general rate case.
Well, there was more than one decision to delay the rate cases. Is that correct?
Yes. So I was referring to the first one.
Understood.
So
did you provide a recommendation regarding the one related, I guess, the later decision to delay the rate case?
So then that case kind of rolled into the next planned rate case, which would have been rates effective July 1 of 2022. When the merger was announced, we did provide an analysis on anticipated timing of when the merger may close, because at that time, as anticipated, we would not file for a rate case during the pendency of the merger application.
Okay. So I just want to make a note of this. Well, I asked you if you made a recommendation at that point, and it sounds like you provided an analysis. That's what you've informed me. That's correct?
That's correct.
Okay. But it doesn't sound like that analysis included a recommendation. Is that correct?
It provided some financial impacts, and it was provided back to Charles Eldred.
Okay. Now, you also state that Pnm delayed the filing of its next rate case due to the regulatory commitment made as part of the Avangrid acquisition of Pnm to delay the company's next rate case, right?
That is correct.
Okay. So now, as I understand it, the current commitment is that Pnm will file a rate case no sooner than December 31st of 2022. Is that correct?
It's December 1st, 2022.
Was it December 1st? Okay. And that was an extension from what was previously put into the stipulation that was heard by the hearing examiner that had a date of, I believe, June 1, 2022. Is that correct?
Yes, that reflected an additional 6-month delay.
Yeah, okay. And I think you indicated earlier today that Mr. Darnell made the decision to delay the rate case to that date. Is that correct?
I believe I indicated that he agreed to that in his rebuttal testimony.
Okay. But he agreed to that. But I think as someone else pointed out, to agree, you have to have somebody else. So he offered that up apparently as a proposal, correct?
Correct.
Okay. So based on this discussion, is it correct to say that these decisions to delay the filing of a rate case were made unilaterally by P&M?
No, I don't believe that's correct.
Who else was involved in those decisions?
I wasn't involved in the merger negotiations, so I'm not sure what discussions were had both with Avangrid as well as with the signatories along that supported the merger.
So how, if you weren't involved in those, how could you say that it's not correct that the decision to delay the filing of the rate case was unilaterally made by P&M?
Because like I said, those concessions were made as part of the merger hearings and I was not involved in those.
Okay. Well, it certainly wasn't made in response to any regulatory mandate, was it?
Not that I'm aware of. It was part of the merger, some of the merger commitments.
Okay. Now the commission denied approval of the acquisition. Is that correct?
I believe the commission denied or approved the certification of stipulation, which recommended denial of the merger.
Okay. And that matter is currently before the Supreme Court.
That is correct.
Okay. Now we don't know what the Supreme Court will do with that appeal, but let's assume that the commission's decision is upheld. In that event, P&M and Avangrid have stated that they plan to refile the application. Is that correct?
I don't know if they've stated that.
You're a vice president of the company. You don't know that they made that statement?
I do not.
Okay. So you wouldn't know if that's a application would be refiled, if it would be refiled before December 1, 2022, do you?
I don't know.
Okay. Do you know that if the new Avangrid application would be filed later than December 1, 2022, whether or not P&M would correspondingly postpone the filing of its next rate case?
Going to object is calling for speculation. The witness says he wasn't aware of any plans for a new filing.
Well, I mean, he is aware of when the company is going to file it or is planning to file its next rate case. And he's also indicated, I believe he said somewhere where P&M decided not to file the case during the pendency of the Avangrid application. So, I mean, I think he can answer this question.
Overruled. Go ahead, Mr. Monroy.
Do you mind just asking it again real quick?
I'll try to do that. So if the new Avangrid application is not filed until sometime after December 1, 2022, will P&M correspondingly postpone the filing of its next rate case?
I don't know when that filing you're talking about, but I do know we are planning on making the filing. We have started our policy team meetings for the rate case, for the upcoming rate case in December 1. We've been meeting for a couple of months. We've engaged individuals who provide information. For example, consultant who does our lead lag study. We've engaged a depreciation witness to prepare our depreciation study. We've engaged our actuaries on our pension. And like I said, we've been meeting regularly to begin preparations for the filing that we plan to make in December.
So is it fair then to say that your decision right now to go ahead with the filing of a rate case is independent of anything regarding the filing of a new Avangrid application?
I would agree with that statement.
Okay. Your current title is Vice President Corporate Controller for P&M Resources and the corporate affiliates, correct?
Yes, sir.
And first, I'll congratulate you. You seem to have a new position since the last time we spoke.
Thank you.
But who do you report to in that position?
So currently I report to Lisa Eden, who's our new Chief Financial Officer. Prior to that, I reported to Don Terry, who was our Chief Financial Officer.
Okay, and that change just took place in the last few days with the new positions that Mr. Terry and Ms. Eden were promoted to, correct?
Yes, I believe that was announced on Thursday.
Okay. And is now Lisa Eden part of the Executive Policy Committee or no?
I believe so. It's fairly new, but I believe that is correct.
It may be too early to know.
Yeah,
okay.
Don Terry would know the answer to that. I believe that is correct, though.
Okay. Who assigned you to prepare testimony in this proceeding?
Who assigned me to prepare testimony? I'm not sure anyone assigned me. I mean, I was heavily involved in preparing the response to the show cause motion. And then as the procedural order was initiated, I began writing testimony in response.
Okay. Thank you. I have no further questions. Thank you very much, Mr. Monroy.
Thank you, Mr. Borman.
Thank you, Mr. Borman. Chief Hearing Examiner Shanauer, do you have any questions
Yes.
for Mr. Monroy?
I do have a few questions. Thank you. Mr. Monroy, could you turn to the recommended decision on the financing order?
Yes, sir, I have it.
Okay, on page 84.
Yes, sir.
Down in the bottom of that page, it states that if P&M has not adjusted its base rates charged to customers in a general rate case to reflect the abandonment of the remaining San Juan plant before the start date of the ETC charges, P&M shall be required to implement an immediate credit to ratepayers as an interim rate adjustment mechanism upon the start date of the ETC charges. The rate credit, with the credit, should include the full value of the revenue requirement of the abandoned facilities. You see that, right?
Yes, sir.
And in your testimony, you presented several calculations of revenue requirement associated with the San Juan facilities, right?
Yes, sir.
And I guess I'd like to point you to your exhibits HEM2 and HEM4.
Yes, sir, I have those.
Okay. The HEM2 exhibit shows a revenue requirement, total revenue requirement of $98.3 million, right?
Yes, sir.
And then if you go to HEM4 for 2022, it shows a total of $58.7 million, right?
Yes, sir.
And then for 2023, it shows a revenue requirement of $645,000.
Yes, sir.
Okay. First, can you explain the difference between the number in the $98.3 million in HEM2 and the $58.7 million in HEM4?
Sure. So the $98.3 million is reflective of the revenue requirement that was included in the illustrative cost of service that was used to set rates. So it reflects the San Juan cost for our future test period of calendar year 2018, and all the components included in there related to San Juan. Versus compared to HEM-4, that reflects the 2022 estimated revenue requirement of what it is related to operations during calendar year 2022. So that includes like projected O&M for the remainder of the year, and projected costs, and includes a 13-month average of the undepreciated investments or the rate base related to San Juan.
And could you go on to 2023?
Oh, I apologize. And then 2023 reflects the ongoing costs specific to San Juan that we had identified in our original application in this case, of costs that would continue beyond abandonment related at San Juan.
Okay, so if PNM were to issue the energy transition bonds this summer, roughly about the time of the abandonment, which revenue requirement would PNM believe is appropriate to use as the rate credit?
I believe in that instance, it would be the $98.3 million as the rate credit that would be implemented once PNM issues the bonds and starts collecting the energy transition charges, as that reflects what's in rates, or that reflects what was included in the cost of service of what the rates are being charged today.
And if PNM were to issue the bonds next year and start charging the energy transition charges next year before it files a rate case, what would be the revenue requirement that PNM would believe would be used as the basis for the rate credit?
It would still be the 98.3 million, because it would always tie back to what rates were set on that are in place today.
So if PNM were to issue the bonds and start assessing the energy transition charges at any time before the conclusion of the next rate case, the value that PNM believes should be used as the basis for the rate credit would still be the $98.3 million?
Yes, sir.
Okay. Okay, thank you. That's all I had.
Thank you.
Thank you, Mr. Schanauer. Mr. Monroy, regarding the date of the proposed abandonment of June 30th, 2022, the originally proposed abandonment in this case earlier, I'm curious, was it tied to the anticipated conclusion of the rate case that you had planned at that time, that you, being the company, had planned?
Yes, they were all synced up as to reflect the general rate case, to reflect the first full year after abandonment on which to reset rates.
But what was the driver? What was the cause? What was of the abandonment date itself of June 30th? Bearing in mind that San Juan Unit 4 is now slated for abandonment in September of 2022. But at the time, Units 1 and 4 were both anticipated to be closed or abandoned on or around June 30th, 2022.
Yeah, my understanding is it was the expiration of the participation agreement with the other owners of San Juan. Also was around that date.
Okay, so that's what triggered or caused the estimated abandonment date.
Yes, sir.
Was the expiration of that agreement, not the rate case.
No, then the rate case was then tied to sync up.
Okay, and that's what you represented to the commission in the earlier phase of this case, right?
Yes, sir.
And so that may have been why in the recommended decision, I know in this case, again, and the reason I keep saying this case is I also have experience with the Four Corners abandonment, which is on appeal to the Supreme Court right now. But I know similar representations or slightly similar representations were made with regard to the Four Corners abandonment. But in any event, in this case, as Ms. Gould touched on, our recommended decision, ours being Chief Hearing Examiner Schenauer and I, say the bonds would be issued shortly after the abandonment of Pnm's interest in the units on July 1, 2022. That's on page 21, right?
Yes, sir.
Subject to check.
I remember that. Yes.
And then on page 27, it says the ETA facilitates and ensures Pnm's recovery of the cost to abandon its interest in the remaining San Juan facilities. And I wrote that, so I hope that it refers to ETA, provides for the issuance of energy transition bonds to enable Pnm to recover the estimated costs, energy transition costs in Pnm'S, of abandoning units 1 and 4 shortly after the abandonment on June 30th, 2022. Right?
Yes, sir. That's what it reads.
And then on page 65, let me just read this into the rec. Pnm anticipates, this is one paragraph. It's the first full paragraph on page 65 of the financing order recommended decision. Pnm anticipates the ETA rider will become effective 30 days after issuance of the energy transition bonds. For example, and this is based on Mr. Setledge's testimony in that case, if the bonds were issued on July 2, 2022, Pnm anticipates the ETA rider would become effective on August 1, 2022, and would be assessed for electric service provided thereafter. Is that correct?
Yes, sir. That's what it reads.
So in the Four Corners abandonment case, 21-00017-UT, you did not testify. I think you testified earlier today, right? You were a witness in that case.
That is correct. Sorry for interrupting.
I missed your presence in that case, but I noted pretty closely, it looked like Thomas Baker took on your role in that case. Is that right?
That is correct.
And at the time, he was manager of service for Pnm Resources. Is that right?
That is correct.
Is he still the manager of cost of service?
Yes, sir.
And most of the reason that I figured that he was taking on your role is that his testimony was almost verbatim what yours was in case 1918 in certain respects, to the extent that the proposal for abandonment and the energy transition bonds and the securitization were largely similar. Is it fair to say that they're largely similar?
I would agree with that.
So he says on page 26 of his testimony in case number 21-00017-UT, on page 26, starting on line 8, following abandonment of the FCPP, Four Corners Power Plant, the SPE special purpose entity will issue the energy transition bonds. And he's talking about there, going down to pay, fast forwarding to line 13, the rate rider that is created will serve as an interim rate adjustment mechanism. And Pnm will continue the rate rider credit for as long as the FCPP is abandoned. For as long as that's going on, Pnm is collecting the energy transition charge and has not adjusted its base rates to reflect the exit of FCPP. Now, on page 27, starting on line 7, he he uses the same, almost the same exact language that you used in your direct testimony in case 1918 on page 41 that I had mentioned earlier this morning that I had highlighted from that case. And he says that actually he starts with the same qualifier, the however. However, if there is a timing difference between commencement of the collection of the energy transition charge from customers when bonds are issued, this is the part I highlighted and emphasized, upon the abandonment, and the time that base rates are adjusted to reflect the abandonment of Pnm's interest in FCPP, then a rate rider credit will protect customers from double recovery of the fuel revenue requirement associated with the abandoned interest in FCPP. Now, the reason I'm bringing up Four Corners is that doesn't seem, my recollection, having worked diligently on that case, it doesn't seem that there was the same syncing of the proposed abandonment date to any particular rate case conclusion. Is that right?
No, I think that was a lot of testimony. So I'm not sure what's in testimony, but I know internally in our original long-term forecast that included the abandonment of Four Corners, we did have a rate case that would go into effect in January of 2025 to sync up the abandonment with the timing of a general rate case.
Well, I'd be careful in making that representation because I don't recall that representation being made, because there was more of an emphasis on the fact that you may have to issue that interim rate credit pursuant to the section of the ETA that provides for it. I think it's, what is it, 4B11?
Yes, and
Right.
Mr. Hearing Examiner, I apologize. I wasn't inferring that it was made in the Four Corners case. I just meant from my perspective, and as we prepared long-range plans, those were the assumptions included in there. So.
Well, again, what I'm driving at, and it was the same for Lisa Eden, the current CFO. Her testimony in the Four Corners case didn't address what it did earlier with regard to what we've talked about regarding those four elements of what needs to happen, the four events. That was taken on by Laura Sanchez, who's going to testify later in this case. And that, I just know for the record that the Pnm, that her testimony in the Four Corners case on page 25, line 15, she says Pnm expects to issue the energy transmission bonds as promptly as possible after the last of the following events have occurred. And it's the same events, the same verbatim testimony. And again, my impression and my findings in the recommended decision in the Four Corners case is that the issuance of the bonds is tied to being shortly after the abandonment. So am I wrong in that impression?
Mr. Hearing Examiner, I wasn't involved in the Four Corners case, so I couldn't comment on your impression.
How about this? On page 30 of the recommended decision, here's my impression. The energy transition bonds will be issued shortly after the abandonment date of December 31, 2024.
Yes, sir, that seems clear.
Is that impression wrong?
No, it's not for me to opine, I guess, on your impression.
Same thing on page 39 of the recommended decision on financing order in case 210017 UT. The ETA facilitates, and then it says it provides for issuance of energy transition bonds to enable Pnm to recover the estimated costs, energy transition costs in Pnm'S, of abandoning its interests shortly after the abandonment, December 31, 2024. right?
Yes, sir.
And so that's why I might have told the commission, and they made the finding that on page 31 of the RD in the Four Corners case, that, for example, if the bonds were issued on January 15, 2025, PNM anticipates the ETA rider would become effective on February 14, 2025, right?
Sounds correct. Yes, sir.
And earlier, you indicated that, and I think it was in questioning by Ms. Gould, but it might have been by somebody else. Forgive me if I am combining the different questioning, but you indicated that, well, the requirements, your understanding of the recommended decision is that the requirements, the actual legal binding commitments, are contained in the quote unquote financing order part of the decision. Where do you think that the requirements start in the RD? Can you point to that?
Yeah, so I believe they start in the both the findings of fact and conclusions of law on page 108
right,
through the ordering paragraphs that begin on page 149.
Oh, that's a good point. Look at the page 108, the very top. And what does it say there? The statement of the case, discussion, and all findings and conclusions therein, whether or not separately stated, etc., are incorporated by reference as findings and conclusions of the commission. So you see those findings and conclusions with regard to the abandonment date and the anticipated date of issuance of the securitization bonds, the energy transition bonds, includes findings and conclusions of the commission and are incorporated into the findings and conclusions, right?
Yes, sir.
And just so we're clear on this and folks are listening, the ordering paragraphs then on page 149 incorporate the findings of fact and conclusions of law, right?
Yes, sir.
I wrote this way a long time ago in past cases. We've written it this way, but I've tightened it up a bit, frankly, over time, just so that when something like this came up, when there was some question about a finding, that are clear that the findings are carried forward into the following paragraphs, being the technical findings of fact and conclusions of law and ordering paragraphs. And the reason this is important is because Pnm informed the commission that the issuance of the bonds, the securitization, would happen shortly after the abandonment. That was the understanding. That was the basis of the application. Those were the representations in the application, weren't they?
Yes, those were the estimates. Yes, that was what we represented at the time.
That's the information that we based our decision on, right?
Yes, sir.
In both the San Juan case and the Four Corners case.
Yes.
The representations were largely the same.
Yes, sir. I believe that.
But Pnm was not planning on informing the commission that the securitization was not going to happen until the conclusion of the next rate case, which would be sometime in 2023, the end of 2023, is that right?
Yes, that would have been the plan.
So Pnm was not going to inform the commission.
I was not aware of any plans. I think the process starts prior to the issuance of the bonds, and so as outlined by Mr. Atkins, so I think the commission would have been involved in some period before the bonds were issued.
So remember when I asked you about asymmetric information?
Yes, sir.
That's the asymmetry I'm talking about.
I understood your point, Mr. Hearing Examiner.
Okay, can I read you something?
Yes, sir.
There are lots. Are you familiar with the concept of moral hazard?
It doesn't ring a bell.
Well, let me read you one definition. And moral hazard is something that you see in the regulatory context in cases involving utility commissions. I know this because I researched it, right? So moral hazard comes up in many different contexts. It might come up in the PG&E context because of the fire damage and the issues that require compensation and rate setting issues. It might come up in many types of different contexts, but one context it comes up in is where there's simply just generally an asymmetry of information. So this is just a definition that I got from Investopedia, but it says moral hazard occurs when there is asymmetric information between two parties and a change in the behavior of one party occurs after an agreement between the two parties is reached. So there was a change in behavior, right? Here, the change of behavior was, well, we're not going to issue the bonds when we said we were, because situation changed, right? But
There was a change in the estimate. I would agree with that.
Right.
Yes,
okay.
sir.
And so asymmetric information, quoting again, refers to any situation where one party to a transaction has greater material knowledge than the other party. Now, moral hazard frequently occurs in the lending and insurance industries, but it can also exist in employer-employee relationships. Anytime two parties come into an agreement with each other, moral hazards can be present. And so here, the potential moral hazard that P&M has, frankly, potentially created is that it's sitting on information about when it's going to issue the bonds based on changed circumstances. Did P&M ever consider whether it was creating a moral hazard?
That conversation did not, I do not remember conversations regarding that.
But there's an agreement there. The financing order is in a form of is effectively a type of agreement, right? It's a commitment. It's a commitment P&M made that with the ratepayers.
I would agree with
right?
that. I would agree with that.
That is supposed to be in the public interest.
I would agree with that as well.
You don't think that you're breaking the agreement with the ratepayers then?
No, like I said in my testimony, I believe we are in compliance with the financing order in this application.
Okay, I understand P&M's position. I don't have anything in additional, so I'm going to pass it over to Mr. Alvidrez to see if he has any redirect. And redirect is generally limited to 10 minutes.
Yeah, and I do not have any. I do not have any redirect, Mr. Hearing Examiner.
Okay, Mr. Monroy, thank you so much for testifying for a full day. As always, you're a good witness, and we appreciate your testimony today before the commission. Thank you, sir.
Thank you, Mr. Hearing Examiner. Thank you, Mr. Schanhauer.
You're excused.
Mr. Medeiros?
Yes, sir.
I believe in the pre-hearing order that you issued, there would be an opportunity to ask, I think, up to 5 minutes of questions based on questions from the hearing examiners or redirect. I do have one question following up on your examination of Mr. Monroy. If you,
I will allow it, and then I'll allow redirect on it or further questioning. Mr. Monroy, I'm sorry. So it's limited to 5 minutes. Go ahead, Mr. Michael.
Thank you. Mr. Monroy, in the last quite Q&A that you participated in with hearing examiner Medeiros. You just said that PNM is in compliance with the financing order. And the crux of this case seems to revolve around the timing of the bond issuance, whether it needs to be timed at the time of abandonment or at some later date coincident with your rate case. I'd like you to turn to page 27 of the financing order. And I'd like you to read, you don't need to read it out loud, the second paragraph from the bottom. It's 2 sentences beginning with the ETA also requires. And I'd like you to take a minute and look at that and study it. And my question is, how can you possibly reconcile the 2 sentences of that paragraph if abandonment and financing occur at 2 different times, 18 months apart?
Okay, I've read it. Can you ask your question one more time? Apologize.
How can you possibly reconcile those 2 sentences in a consistent way if abandonment and financing occur 18 months apart?
I don't know if it's for me to reconcile the 2 sentences in the financing RD. I believe, as we've stated, our position is that in the totality of the financing order, it did clearly lay out that the issuance of the bonds was an estimate, was not required to be tied at abandonment, and that the proposed rate-making method under the ETA and ultimately what was approved is triggered upon the implementation of the bonds and the energy transition charges becoming effective.
So you are not going to provide any reconciliation of those 2 statements, those 2 sentences?
I'm not, no.
That's fine. Okay, that's all the questions I have. Thank you.
Thank you, Ms. Michael. Any redirect, Mr. Alvidrez?
No, sir.
Okay. Now, Mr. Monroy, I apologize. In my haste to excuse you, I skipped over that piece, but you are now excused. Thank you, sir, very much.
Thank you, Mr. Hearing Examiner.
Okay. Thank you. Folks, we're at 4:38. I don't know whether it's worthwhile to continue at this point with would be the next witness would be Mr. Atkins for any period of time. Hearing Examiner Schanauer, how do you feel about the situation?
I don't know. Why don't we talk about tomorrow right now?
Okay. Well, I was thinking it would probably be better to adjourn for the evening and then have Mr. Atkins on first thing at 9 a.m. and then just follow that with Ms. Sanchez. Of course, we'll have our ruling on the NM areas motion in limine. But
I thought there was some interest in getting Andrea Crane on
first. That's right. So I forgot about that. We need to have Ms. Crane on first and then slot in probably Mr. Atkins and Ms. Sanchez, but we also have Mr. Terry. So Mr. Alvidrez, what do you propose of the order?
Well, as we indicated in the filing, I'm not available on Wednesday, and I would be the one presenting Mr. Terry. And I maybe I'm being presumptuous. I'm hoping you'll indulge me and not require me to be here on Wednesday when my son graduates.
Oh, absolutely.
But,
Absolutely not. No, that's why I'm suggesting that we start with Ms. Crane and then go to Mr. Terry second.
Okay.
Ms. Crane is slotted for 9/10 of an hour, I think, of cross-examination. But she's not available later on until after 2. So probably be good just to get as a cleanser to go with Ms. Crane first and then go to the main course, Mr. Terry, for the day.
I don't know that he agrees his characterization as the main course.
That
but-
was, I'm just being flip. I apologize.
No. And then we would follow with Mr. Atkins and then Ms. Sanchez.
Yes.
Okay.
And we try and get everything done, but we might not.
All right.
So the plan would be then to start with Ms. Crane at 9 a.m. and then we'll have Mr. Terry on and then Mr. Atkins and Ms. Sanchez. Mr. Setledge has been moved to Thursday, probably Thursday afternoon, pursuant to our prior agreement this morning.
Your Honor, this is Mary Ellen Lanassi, and I have a question. Can I move 10 minutes from Mr. Atkins? So I had 15 minutes, and can I move 10 minutes from him to Mr. Terry, which would be 70 minutes, and leave just 5 minutes for Mr. Atkins?
Is there any objection to that? So I'm placing 5 minutes now with Mr. Atkins and then adding, how many minutes was that? 15?
10. Yeah.
10.
So then
10,
it would
70.
be, yes, please.
Without objection, that is granted. So I have you now with 5 minutes with Mr. Atkins and 70 with Mr. Terry.
Thank you so much.
And you're welcome. Any other adjustments proposed? Okay, anything else to address before we adjourn for the evening? Okay, very well then. With that, we are adjourned until 9 a.m. tomorrow morning. Have a good evening all.